Hey, everybody. This is your friendly host, Joel, the guy from Surviving the Survivor. Looks like we are live here. This is going to be jury instructions in the Kouri Richins trial with closing arguments set for Monday. I am not sure if Joe is going to be joining today. She's in Italy. It's late there, and I'm really not sure. However, I'm here just for a few moments, probably like 15 minutes. I have to go get my daughter, and then the COE and I are going to see Lady Gaga tonight. So, but you guys obviously are not only more than welcome, but should hang out, can chat, and as these jury instructions go on. Thanks for asking about the knee, Sully and Sam. It turns out I have a completely torn right meniscus, torn completely. So it's the next thing I got to deal with. But for now, it's just this trial in front of us today. It is Friday afternoon. It's late on the East Coast. And by late, I mean 3:00 p.m., 1:00 in Utah. No idea how long this is going to take. Again, I'm just on standby waiting for my daughter to call, and then I have to go race to pick her up. But we'll keep the stream going for you. And thank you for being here. I appreciate it. If you missed it, Karm and I just did a show talking about Women Gone Wild, and includes Kouri Richins and 3 other stories of women/moms who are in some serious hot water for a variety of reasons. We just went through all of that, but we are here. I think I saw Joe pop in. She, I think, is getting ready to hop in. Or do I have to let Joe in here? I think I do. Hey, Joe.
Hi.
How are you? I was just telling everyone, this is another daughter. I have to go get my daughter in about 15 minutes, and then the COE and I are going to see Lady Gaga tonight. So,
Great.
Yeah, so I am out of here in probably about 15 minutes as soon as my daughter calls. But I mean, Joe, how long?
We'll miss you. We'll miss you.
I'll miss you. But how long are you expecting jury instructions to go here, and then closing?
I don't see why they should take that long. I think that they've already at least made some stab at them, and most of them are pattern instructions. But having said that, the defense surprises me all the time by taking more time than I can imagine something could take. So with that caveat, I don't think it should be more than a couple of hours.
All right.
But that's a big caveat given what the defense has, my experience watching the defense so far.
And let me ask you this. I mean, from a defense perspective, what is sort of their primary goal with these instructions?
Well, for both the state and the defense, the primary goal is to make sure the instructions are clear and accurate, because the jury obviously has the fact-finding role, but if they're given the wrong instructions on the law, then their fact-finding is going to be suspect because they didn't apply the right legal standard. I think the defense obviously will be looking to get wording on instructions that is, most favorable to the defense, but then so will the state. But I think overall, the objective of both sides should be to get instructions that are going to be clear and accurate. And the defense may have a couple instructions they want that the state may not want the judge to give, and vice versa. The defense may have a couple of instructions that they want the jury to be instructed on that the state may oppose. That's always possible.
And then looking, I didn't see. I know there was a Tyler Robinson hearing earlier. Someone saying that Kathy Nestor was not there, but there's a hearing about whether or not they're going to allow. And there's going to be another hearing about whether they're going to allow media in that case. But obviously, Kathy Nestor has got her hands full if she's handling that trial as well. But Joe, what are you expecting Monday? Now we're going to get closing arguments.
Right. And then the judge will instruct the jury. I don't know in Utah whether the judge instructs at least preliminarily on the law, and then there are closings, and then the judge finishes up with instructions, or whether the closings happen and then the judge instructs. And And I also don't know whether the judge is going to put time limits. I mean, in the Canero trial, both sides went forever.
Yeah.
And I hope that there are time limits on this. Remember, Judge Everett gave the state and the defense not even an hour in that case.
Yeah.
So I'm hoping these instructions, that they won't be allowed to go on forever. If everything is reasonable, I think this should be submitted to the jury on Monday mid-afternoon.
Are you expecting a quick deliberation here, or you think this goes on for a little bit?
I think it will go on a little bit because there are a couple of charges where I really think a case can be made for reasonable doubt. One of them is the attempted murder, that February 14 murder, where I don't know whether jurors will think there's sufficient evidence to show Kouri obtained poison and tried to kill Eric. And so I think they may have some difficulty with that count. Otherwise, I think the big issue, well, on the forgery, of the document, they may argue some about whether she intended to defraud, but I think the judge's instruction on that may make that go away. And then I think they may have some issue even with the murder, the aggravated murder charge. Again, whether there is enough evidence to show that she procured the drug and gave it. There have been a lot of people in the chat, Joel, who've been saying there's not enough evidence. And what I've said is, if you take a murder case where somebody used a gun and shot someone, that case is not going to be one where the person who's accused told people or confessed to it. You may not find the gun. Clearly, there won't be any witnesses to it. In that sense, this poisoning and any other murder case are really alike. What makes this one a little different is the defense has, I think, at least a credible claim that there might be another way that Eric procured the drugs. And that's where I think the jury may be wrestling, whether the defense's claim that the state didn't prove that Kouri had got the drugs through Karm, through the drug dealer, and then administered them. I think there's certainly enough evidence to prove it, and you prove the intent. You always prove it. Not always. You mostly prove it circumstantially. In a case in which you shot the gun and you don't have the gun and you don't have the bullet and you don't have witnesses and you don't have a confession, you do it by take the Adelson case. You do it. You get those two shooters by the fact that they were in the car at the time and there were emails going back and forth. You do it that way. So I think here, this is long-winded and I apologize, but I think here a lot of this will depend on how well the state in its closing ties everything up and provides a consistent, coherent account of how she did it, rolling in all the evidence and the inferences from the evidence.
Thank you for that, Jeremy. That was my daughter, by the way, who's running late, so I'll be here a little bit longer. She informed me that it is pouring outside, and she's on the bus and says it's going to take a while. But Jeremy Pearson in Minnesota, I was surprised there was no defense put up. Joe Picciuto, were you surprised?
Yes, but mainly because the defense all along had been claiming they had a lot of witnesses to call, and as recently as the night before, they were saying they had two witnesses and they would be ready to go yesterday. And then when push came to shove, they said they were resting. So I was surprised. I think what it clearly shows is they think their best shot is right now saying the state didn't prove enough. And they think that putting witnesses on will open up their witnesses to cross-examination that may weaken the defense case. And they're willing to stand on the state didn't prove it beyond a reasonable doubt. But I was surprised. Not surprised that Kouri isn't testifying. I thought they would have had lost their minds if they put her on the stand.
Yeah, I think that's probably accurate statement, particularly after the forensic accountant. But Katie here says, walk the dog said it all. Is that the death knell in terms of the evidence against her? Is that going to really destroy her when they go to deliberate?
I think it's clearly going to help. I mean,
Yeah.
it's hard to read that letter as what she said it was, the sort of an outline for a book she was going to write. I mean, it really looks clearly as a script for here's what you need to tell Sky Lazaro happened, and be sure you tell her the first time you talk to her, or otherwise she's going to be suspicious. So yeah, I think it certainly helps a lot. I think another thing that helps a great deal is that 15 minutes in the bedroom where the phone is going on and off. When she said as soon as she saw him, she called 911, and the phone evidence certainly suggests something else.
Just back to jury instructions, I think a lot of people, including myself a little bit, don't fully understand, because you think, well, there's just instructions, but how much leeway does a judge have, and how much influence does the government and the defense have in terms of influencing the judge with instructions?
Well, they're pattern instructions that there's not going to be much influence on. There's a pattern instruction that says, here's what aggravated murder is. So there's not going to be much argument that they want something instructed different from the pattern instruction that's been used in Utah, and that's probably been signed off on by the state Supreme Court. On the other hand, there may be other things that relate to the specific facts in this case that the defense may want. And there are pattern instructions even with regard to those, consciousness of guilt, for example. But there may be nuances in the facts that the defense wants articulated in a particular way. And that's where the play will be here. And so there's some leeway, but the judge has got to make a assessment on the facts as to what's the fairest articulation, or the most objective and fact dependent articulation of those other instructions. And my guess is he will lean towards what the state says, because all along the defense has overstated, stated in generalities, has been a little off on what the facts actually show. And he's been correcting the defense from the beginning of this trial. So unless the defense gets a lot better at this, if they're going to be making a fact-dependent argument about how a particular instruction should read, I don't think the defense will prevail.
I am just tweeting out to people to let them know that this is going on now. It was supposed to start at 3:00. By the way, if you're not following me, please do on Twitter. I'm at Podcast STS, also known as X, at Podcast STS. Instagram at Surviving the Survivor. Please make sure you give Prof. Joe a like and a subscribe. Same with Surviving the Survivor. Yeah,
and
there's
videos for both of us.
Yeah, they're supposed to start 15 minutes ago. I'm wondering, any thoughts about what is causing the delay here, Joe Patudo?
Nothing fair and objective that I can say. I do have a thought, but it isn't fair.
Okay. What is it from Wendy England here? What is the theory of what Kouri was doing in those 15 minutes in the bedroom when Eric was dead before she called 911?
I do not know. I have not heard an explanation, her explanation for those 15 minutes. And they're pretty suspicious. There may be someone in the chat. I don't know if this came up in a preliminary hearing, but I don't know the answer to that. But it would be interesting to hear the explanation.
Yeah. I mean, and Joe, then here's another interesting comment. And I think this is a lot of people are feeling this way. I did not like, a lot of people just personally did not like the approach or the temperament of the defense. How critical or not is that? I mean, how hard is it for jurors? My question, I guess, would be to separate themselves from the human instinct to, not like a particular type of personality.
I think they will try very hard to separate it. I think jurors take their job very, very seriously. You've heard jurors interviewed after several trials, and it's impressive how they talk about how they went about their job. So I think, and I agree that there may well be jurors who will not like the defense, the style, the repetitive nature, the inability to lay foundation, all of that. But I think when they deliberate, they will do their best to set that aside and look at whether the evidence is sufficient to convict. Now, subconsciously, will it have an impact on how they evaluate the evidence? I mean, you can't say no to that. But I do think consciously they'll make a real effort to separate it.
Let's see here. They lost when the defense let Carmen Lauber, who's the one-time housekeeper, story about an investor who wanted drugs go unquestioned. All they needed to do was produce him. I don't know.
Well, but you can say that about a lot of the evidence. I mean, if they wanted to say that Ronnie should have been interviewed, well, Ronnie's her brother. They could have called Ronnie. I mean, you can go through this and find a lot of places where they're doing on cross or trying to push on cross with witnesses that they could call on their own or other witnesses that they could call. And I think they think, particularly somebody like Ronnie, I think they think that would be a real, time bomb that might go off on them. And it's up to the state to prove its case. And the state is not allowed to get up in closing and say, they said there's not enough evidence for this, this, and this. So why didn't they call so-and-so? And why didn't they call so-and-so? Because that really gets to the state. The defense doesn't have to put on any case at all. It's up to the state to prove beyond a reasonable doubt.
Yeah. From Lindsay, I assume she was getting rid of the quote-unquote medication before she called 911. I guess that's one possibility.
Possible, yeah. But she also could have done that after she administered it. I mean,
yeah, that's true too.
Didn't have to wait until he was dead. I mean, I don't know. I've never committed a murder. I want everybody to know that.
Really?
But I think you could get rid of a lot of it before the call.
Are you willing to take a polygraph, Joe Patillo?
Absolutely. Yeah. As long as they don't ask me personal questions about other things.
Jeremy Pearson from Minnesota becoming a member. Thank you. Who wrote the walk the dog letter? I think it was Kouri who wrote it.
Kouri. It's her handwriting, and she's not contesting that it's her handwriting. She certainly can't contest now because the defense didn't ask any questions on cross of the detective regarding how he knew it was her handwriting. So they're admitting it's her letter. I don't see how they're not going to do that.
Yeah. We are, this is interesting because he has been, Judge Richard Zarek has been on time pretty much every time. Mostly.
Yeah.
But we're running.
We haven't seen his head. Usually we see his head pop up.
Yeah.
No head.
Yeah, and he's 6'4", so it's hard to miss it. But they were supposed to start 17 minutes ago, and hopefully it's going to start soon. We heard some audio a few moments ago, and then that disappeared. But again, just real quick, so Karm and I just did an hour and a half show, but we started with Kouri Richins, and I was asking her about the writing of the book and finding out it was a ghostwriter and just sort of the psychological her psychological assessment of Kouri Richins and how mothers can kind of betray their children, and less so their husbands, but their children. So Karm had some interesting insight. It's going to be under the live tab if anyone wants to check that out now, before, after, whenever. But we're just waiting now for the judge to get in here. And there's a little movement on the camera right there, but I'm not sure what is taken here.
I don't know either, but I said yesterday that I thought they would start on time. However, the defense throughout has managed to find other things to talk about that has delayed and added time to a good deal of this trial, and that I wouldn't be surprised if something happened today that did the same thing.
So you broke up there on my end. Say that last part one more time.
Yeah, I said the defense has managed to find ways to intrude other issues after they've said everything is settled, and to take more time. And I said yesterday I wouldn't be surprised if it happened again.
Wow.
So
I
So
was here
somebody,
at I
go
was
ahead.
here at 3:01 right after. I mean, I was literally a minute late, so I don't know if something happened. If anyone here saw something, because Spacey started the feed. I don't think anything happened. Like, I don't think anything happened on camera. But if you guys uh, and Jersey Red right now saying the judge hasn't even, haven't seen the judge in court yet. But Capizzi is saying it's the defense's fault, whatever's going on. Uh, and I tend to agree with that. So,
Well,
um,
let's be a little more neutral and say it is something the defense has asked for or wants that's caused it, rather than call it a fault, because, it may be something valid, you know,
it could
but
be, someone's saying that Nestor's in court with Robinson, but someone else said that she wasn't in court. And I think that hearing is over, but it's interesting because it wouldn't be in this courtroom though, right?
no,
I
no,
don't think they're anywhere
no,
near each other. So,
no, no, it
um,
wouldn't be in this courtroom.
yeah,
Are they in the same county?
I don't think so.
Okay.
I don't think so. I have to
No, I
double
can't
check.
imagine that because this trial is ready to go to closing. I mean, she doesn't have to be here for the jury instruction conference. There are two other defense lawyers. And
Someone
it
is saying
was,
that she was there. So
okay,
people are saying conflicting
okay.
things.
Well, that's
Um,
possible. I mean, it was Ramos who made the legal argument on the motion for a directed verdict. So he may be the one of the three who's going to handle the more quote unquote technical legal arguments. And that's what the jury instruction piece is.
hmm. What do you think, Joe? I mean, there's going to be another hearing about whether or not to allow media, to televise and allow media to basically not cover, but report on it live. For the Tyler Robinson case, what's your gut tell you?
Well, before I get to my gut, I think it would be a travesty if cameras are not allowed. I am really a very, very strong advocate of having cameras follow trials, and not because it gives us a chance to cover them, although that's probably a part of it, but simply because I think the public has a right to be able to see what's going on in trials, not simply because of an interest that the public might have, and it's part of our responsibility as citizens to see that justice is administered fairly. But I think for even the defendant, although I know they always argue we don't want the public to hear, we want it closed, there's going to be prejudice. I think the system is much better off when people can see what happens, when they can hear the arguments. You have a much better way of assessing things than if you're not there. It's much easier when you're not there to criticize everything. My
Ooh,
gut is, I know in this case the judge closed a lot of the preliminary hearings and the documents were closed, and but my gut is that will be a public trial, and the cameras will be allowed in. I just think there's so much public interest. It's such an important case.
yeah.
Uh,
Well, Lee from Tennessee is saying, Joel, the media is allowed. The judge ruled. I didn't know that the judge ruled, but that would be our answer.
so
Not
it's
that
good thing I got it right.
Yeah, and not that I don't trust you, Lee, but let me see some backup on that. I did not realize, and I was doing a podcast, but I did not know that the judge ruled. But this is another interesting 19 Michelle. Um, could Kouri be asking for a plea deal now? Joe Patuto, is that a possibility for what
She
is?
could be asking, but I cannot imagine that the state would be interested in making a deal. It's
Hmm.
not impossible. She can always ask, but you got to have two to play that game. It's like a marriage. Somebody can ask you, but the other side has to say yes.
Someone is saying there's no way Kouri asked for a plea deal. Um, Here comes the
Look who's
judge.
here.
Look at that.
I don't know what he does when we lose his head. What is he doing?
I think he's sitting.
Oh, okay.
I think another new member here. Steph's cardio dance. Look at that. Steph's cardio dance. Um,
There's this little, I mean, I like when I see just the little top of his head.
yeah. Well, 6'4".
Hmm.
That's a tall guy because that seal is pretty high up.
Hmm. particularly if he's sitting and you think he's sitting.
Someone says Kouri's a gambler. She's not looking for a plea deal.
She's definitely a gambler. I mean, the way she was playing with all that real estate reminded me of a gambling addiction, except you're using money and housing rather than dice, or roulette wheel.
Primetime KCL. Yes, Joel. The Judge Graff, did rule in the Tyler Robinson case that cameras are allowed in the courtroom. And Erica Kirk also has requested cameras be allowed. When Primetime, let me know, when is this trial supposed to, do they have a trial date set?
Didn't they just say May something? No, maybe I'm mixing. No, take that back. I think that's a very, very different trial where I saw that. It was the Blake Lively, Justin Balzoni case where the judge gave them until May. So,
typically we don't dip our feet into anything politically related, but this is a murder. I'm curious what your thoughts are. Do you want us, just by a show and chat, would you like us to cover Tyler Robinson's assassination of Charlie Kirk? That trial would be interesting for sure. I would even consider going out to that.
I think that'll be interesting. Some of the arguments that the defense made there were, I would say, interesting. Trying to get the entire prosecution team disqualified because the daughter of one person in the office had been in the audience when Kirk was killed. Just really interesting arguments. I'm concerned. That one I think is worth watching, if only for the fact that if the judge apparently is new to the bench, and watching the defense in this trial, I think if the judge is not really strong and decisive, that trial could turn out to be a real circus.
Tyler Robinson, you're saying?
Tyler Robinson, yeah.
Yeah.
Because Nestor's one of the lawyers on it, and watching them in this trial making arguments, general arguments rather than specific, not relating to the law, repeating arguments, having to be told over and over again they have to lay foundation, making arguments that I thought had no merit. If you don't have a strong judge, that can get way out of hand.
Yeah, by the way, the Courtney Clenny case, that's the OnlyFans model accused of killing her boyfriend. That is in Miami in April, and I will be going to that every day. We'll be covering that because a lot of people are asking. As far as Tyler Robinson, it looks like everyone's split. One person says yes, one person says no.
State of Utah versus Kouri Richins. Counsel for the state, Mr. Bloodworth and Mr. Burmester in the courtroom. In the courtroom is Ms. Nestor with defendant, Kouri Richins.
The other
participating via WebEx are Ms. Lewis and Mr. Ramos.
Oh, they're not there.
Let me just provide a little context for where we are at the moment. I have given an honest try to updating the previous proposed set of jury instructions to reflect some events that occurred during trial, to reflect some, though not all, yet, of defendants' proposals received by the court this morning. I've also provided a working copy of a proposed verdict form. This will be an iterative process. We need to go page by page. I expect I'll need to take breaks from time to time to consider the substance of your arguments. Let's just take it one step at a time. Mr. Bloodworth, Mr. Burmester, anything general before we begin?
No, nothing general.
Ms. Nestor?
No, Your Honor.
All right. So may we go by page number, working off of the draft that the court just provided to counsel. Pages 1 through...
This is really important because this is
1
the place
through
where
14 are the opening instructions that the court gave prior to opening statements.
Right.
Okay.
Yes.
So he
Any
gave
objection
these
to
already.
including those in the closing instructions, Mr. Burmester?
No.
Okay. Ms. Nestor?
You want to reread them?
No,
Oh, good.
I'll start reading at page 15.
Oh, great. Then
But
I have no objections to them going back.
recent appellate decisions have chastised district court judges for not including them in the final set. So.
No problem.
Okay, pages 15 through
Important because a lot of reversals on appeal come from errors in jury instructions.
23 are Muji second standard instructions without modification that were also part of the party's proposed instructions submitted prior to trial began. Take a moment. Take
No
us a minute.
objection from the state?
No
Okay.
objection from the defense.
Okay. Ms. Nestor, pages 24 to 25 is the substance, I think, or is a Muji standard instruction regarding in-custody informants. It would require maybe a little editing to remove some unneeded syntax.
Fuji is model.
So first, I need to hear from
jury
the state about
instructions.
whether they have a general objection. And second, we need to make this specific, if it were given, to the time periods that Ms. Lauber was actually in custody and the evidence regarding those periods. Because she's not in custody during the time she's on the stand.
Right?
Your Honor, the state objects to this instruction because this is for a snitch. She's not a snitch. It's a different circumstance. Now, the defense has proposed an instruction,
From the 10th Circuit,
Right.
yes,
state, yeah,
that Garcia
right.
instruction, which seems more nuanced for the circumstance that we're talking about. So if we have to have one, then that would be the one we would prefer, rather
Okay.
than this snitch instruction.
I looked at the case that is the genesis of this. That informant was in custody at the time of trial and came from jail to trial and from trial back to jail. And so I recognize that this case isn't that.
The other thing is, Your Honor, the witness credibility instruction number 20 from page 22 allows both parties to argue whatever they need to under this circumstance. I mean, the unique thing is there is the idea that she was given immunity, or the testimony about immunity, as well as foreclosure. So that all is great for argument, but I don't know that we need any special instruction, given
Okay.
that neither person was in custody at the time they testified.
Ms. Nestor.
Your Honor, I think case law is really clear that witnesses who are either granted immunity or are bargaining in a jail setting for their own freedom when they give information, which is the circumstance with Ms. Lauber, are a special category of witness. There are things that a jury can take into consideration that exceed what is contained in the normal witness credibility instruction. In this particular case, while I agree there may be some editing we need to do on the in-custody informant, I think the importance of this is she was making a statement with the understanding that, that her freedom was contingent on it. And I think that this is an approved Muji instruction. I think I agree we should probably limit it. When I submitted it, I was thinking all her interviews, she was in custody. But I didn't think about the fact that
Agreed.
she's no longer in custody. I never really looked at this instruction that way. I always looked at it as of the time that they cut the deal. But I could be wrong about that. So I don't have an objection to adding dates that she was in custody, if that is of concern to the court. I do think she made it pretty clear when she was here she wasn't. So I think the jury knows she's not currently in custody, but it doesn't matter. I'm fine putting those dates in. But I think the immunity one should be given in addition to this, because the immunity agreement also covers federal immunity, state immunity.
Yeah.
I think we should get both. And we can just take out whatever on this in custody informant doesn't fit our facts. We can just jettison it. But we are asking for both.
There's a general
Mr.
instruction.
Your Honor, a couple of things. First of all, if we're going to identify a witness by name, it should include all of them that come within the definition. So it's not just Karm and Lauber, it should be
Understood.
Crozier.
The periods during which Mr. Crozier was giving the interviews, he was in
Yes.
custody, correct?
Yes.
Okay.
Well,
In fact,
one-
we saw
one
an interview
yeah.
with him in custody, in
Right.
stripes.
Same with Karm and Lauber, right?
Yes.
Yeah. Okay.
And once again, this instruction is designed for the situation where the snitch doesn't know anything about the facts of the case, wasn't a witness to anything. They just happened to be a cellie or something like that. And that's what this was designed for. That is not this case. Both of them were witnesses to the things they observed. There was discussion about immunity, and for that reason, we object to this snitch instruction. And if we have to have something, then maybe either add to the witness veracity instruction or something along the lines of Garcia mentioned before.
So there's a general instruction about the
All right.
credibility of witnesses. And that's what the state wants. It doesn't want
Let me
anything
think
else
about this for a
added.
moment. Mr. Burmester, putting this instruction aside for a moment, any objection to including the 10th Circuit form instruction from Garcia?
I think the 10th Circuit instruction from Garcia is fine, but I think it's duplicative if you're talking about the snitch instruction
Okay.
as well.
I understand.
And the defense wants a specific
And Ms.
instruction to
Nestor, I
say,
understand defendant's position to be the state should give both instructions properly edited.
Right. It is occurring to me, if the concern is, there is a federal instruction that we often use when we have what are called unindicted co-conspirators, that are people that were actually involved that then flipped on whoever's didn't flip.
Provide helpful information.
Yes, sir.
Yeah.
I don't like that word snitch, but
Yeah.
That one may be closer to the facts of this case. I just than this one is, and I can pull that up really quickly. It's a 10th Circuit pattern instruction for unindicted co-conspirators.
I'll take a look at it during a break.
I'll submit it.
Yeah, okay. We'll come back to that. We have
Okay.
time.
the defense wants
Okay.
another instruction.
I've made some notes.
Specific
We'll
to
return to this issue at some point.
Harmon Lauber and
Okay.
Crozier.
Pages
saying
26,
They got an immunity deal
27, 28.
and that is
Standard
specific
Muji
reasons
second.
why.
Closing instructions. Any objection, Mr. Burmester?
No, Your Honor.
I'm sorry. Which pages, Your Honor?
26, 27, and 28.
I think you have the fact versus expert witness in here twice. I think you have it on page 32 as well.
That's entirely possible.
So I don't have an objection to it. I just think we need to only have it on once.
Yep. I will take it out of this position. I'll omit page 26, keep page 32.
Okay. All right. And then the presumption of innocence is fine. The reasonable doubt, I understand this is a Muji. I understand there's some litigation going on as we speak in other states and in this state. It has been at least touched on that the language that if that evidence that reasonable doubt is evidence which leaves you firmly convinced that the defendant is guilty of the crime charged. There is some real question if firmly convinced actually properly describes what reasonable doubt should be. I understand this particular instruction has been accepted by the Supreme Court, I think in case law and obviously in Muji. So I concede that I'm not, but I would like to preserve that error because I'm not sure that's going to remain this way forever. And so we object to the language of firmly convinced as being not strong enough to describe what beyond a reasonable doubt is.
Oh, I have to bounce.
I
Joe, thank
understand.
you. I'll see you guys
And
Monday for
the
closings.
Record reflects
So long.
that the defendant is objecting to the definition of beyond reasonable doubt as evidence that leaves the jury firmly convinced that the defendant is guilty of the crime charged. The court notes that defendant's objection and argument is based on State versus Wall, 566 P. 3rd, 833, paragraphs 51 through 55. On balance and based upon the current weight of Utah Appellate Court authority, defendant's objection is respectfully overruled. Anything further on that, Mr. Burmester?
No, Your Honor.
Okay.
And then what was the last one you went through, Your Honor?
Well, then we go to page 29,
Right.
which is not a Muji standard instruction, but is a copy and paste from the last paragraph of burden of proof from the opening instructions.
Yes.
I see no harm in giving it again. This is what you asked for, right,
Yes.
Ms. Nestor?
Yes, thank you for doing that.
Mr. Burmester, any objection?
No.
Okay. Bear with me, folks. Let me just make sure my notes reflect what we've talked about so far. Okay. That brings us to page 30,
No
Muji
objection.
standard instruction.
No objection.
Mr. Burmester?
No objection.
Okay. Page 31 is the court's effort at a 404B instruction. It uses the structure of the Muji second 404B instruction, inserts the case-specific language requested by defendant. Mr. Burmester.
Your Honor, if the court is inclined to give this instruction, we would ask that it include all of the 404B non-character purposes, not just motive. But
Do you have any other non-character purposes for that evidence?
yes, Your Honor, like all but one or two of them, I think, can apply.
Well, but as I understood, the only reason, and when I instructed the jury in real time, the reason I gave them was motive. Was you weren't, was it also go to
Can it go
preparation?
to identity, preparation,
I know it
intent?
can, but we tried the case. Is that why you admitted it?
Your Honor, I should probably speak to that
Yeah.
one. The answer is yes, and it's been throughout our briefing since, the entire motions in limine practice, we, argued for the admission based on motive, intent, plan, and preparation, and identity. Those words are always lumped together in our briefing.
I know, and talismanically, but not necessarily with factual basis. And so help me out. If I'm going to tell them that they can consider them for those specifics, there's got to be a basis. Or we can say other purposes such as motive. The reason I'm coming back to this is I want to be as close to the instruction I gave them as real time as possible, which we litigated in real time. And I didn't say the talismanic words in real time. I said motive.
Yes, Your Honor, but I think the court said motive based on what the defense was requesting in the instruction. The state wasn't limiting the instruction at all.
May we say such as rather than all of those combined?
I'm sorry, could you just say it in a sentence?
Yeah, such as determining motive, preparation, plan, or identity.
We should accept that.
Or determining things such as motive, plan, preparation, or identity.
For the limited purpose of determining things such as the defendant's motive, plan, okay.
Yeah.
Yes, sir.
Okay.
Yeah, you should accept it.
Ms. Nestor.
Well, I think the core was great initially. I've never been under the impression identity was an issue in this case. I don't understand how any of these things would go to plan or preparation. I think the way it's written is correct, so I would object.
Certainly the first bullet point would go to preparation or plan.
Yep.
Plan, not so much preparation.
I just would like the record to reflect we object to it, Your Honor.
Okay, hold on a second. I'll just make a note of this. We'll come back to it.
There's another we're coming back to. Everybody understand that? He wants to, the instruction is you can use it for these purposes. The defense says the only thing that was ever argued was motive. The state wants motive, plan, preparation, all those exceptions to the hearsay rule. But in order to have all those exceptions listed, the judge says you got to have something in the facts that would show it could have been her plan, her preparation, her identity. And so that's where the argument is. He wants to go back and, I think, review the facts and the arguments and
Okay.
see if
32.
plan, preparation,
33,
motive,
34.
and maybe other things are reflected in the
32
facts.
through 36 are Muji second standard instructions.
No objection from the state.
Your Honor, on 33, the law enforcement officers, I think that should be plural. Many law enforcement officers testified. So I think we have it in the singular right now.
Okay. You heard the testimony of law enforcement officers.
Yes.
Got it?
And then the rest, I don't have any objection to.
Got it. Will do. Okay. 37 versus page 38. 37 is the motive instruction that the parties proposed pre-trial. It talks about Kouri Richins' motives, plural, which is a little fuzzy regarding the law. Here, there are two aggravating circumstances. One qualifies as a motive, the other qualifies as means. The motive would be an element to the extent it's the aggravating circumstance. The means is an element to the extent it's the aggravating circumstance. In the abstract, if the jury were to find unanimously regarding the means, but were not able to reach unanimous agreement regarding the motive, there'd still be a basis for a conviction. So the the court proposed the version on page 38.
Can I clarify? I was with you up until the very end of what you said, but I think the court's probably right. Are you saying that the only thing that requires the motive is the subsection 1 of the aggravated murder, which is committing homicide for pecuniary gain?
Well, so if we go to the elements instruction, we just
Right.
want to look at that together as an
Right.
example. So go to page,
Motive is
For
not an
example,
element of
page
aggravated
41.
murder.
Right.
you could have 8 jurors that unanimously agree on elements 1, 2, 3, and then when it gets to 4, they're going to have to unanimously agree regarding one of the 2 at least.
Correct.
Now, they could unanimously agree regarding 4B without ever agreeing regarding 4A and without ever agreeing about a motive at all,
Right.
just regarding the act.
I think that's right.
And so the way the parties had written it beforehand did not contemplate that possibility.
I think you're right.
I'm just not convinced that motive is coextensive with intent. And I think the state is required to prove it was the intent of the defendant to cause the death for the purpose of.
Yeah, the difficulty here is the pecuniary gain
Right.
is a why, not a how, and why is motive.
Right, that's right.
Well,
They're
if
both
you-
right.
Motive might be my financial situation is so distraught, I'm going to commit this murder. Or I'm just so darn greedy, I just want more money, so I commit a murder. I think motive might be involved in both, but I have to prove that was the intent to do it, was to make the money, whether you had the motive, this underlying thing or not. I don't know.
I believe intent goes to intent to cause death.
That is among the things that the jury would have to find unanimously.
Right. The the pecuniary gain is clearly motive. That is a motive that they've alleged. And I agree that I think subsection B does not require a motive because it doesn't matter why she's administering the lethal dose, just that she is administering the lethal dose. And I think we just missed that in the one we submitted. I think the court's right that motive only applies to 4A, and so it's tricky to explain this to a jury without a side-by-side analysis of the elements instruction.
Now, another option, right, is just to not give a motive instruction.
That would
Right.
probably be the best. Except that,
Because then we don't have to get confused about whether the why is part of 4A versus 4B. We can just not instruct regarding motive.
I mean, I do believe the motive is there in the elements instruction, whether we explain whether it's a motive or don't explain whether it's a motive, they still have to prove this. So I'm okay with no motive instruction.
If we take the motive instruction out, it kind of frees everybody up to talk about what they really mean
Right.
without having to thread the needle of what's an element and what's not.
Let's do that, Your Honor.
Yes.
Okay. Any objection, Ms. Nestor, to omitting a motive instruction entirely? A separate motive instruction?
I think it's just utterly confusing. It's going to confuse the jury. I think we should take it out.
Understood. Pages 38 and 37 are omitted.
She's
Okay.
being very reasonable so far.
Page 39 includes definitions. In fairness, I'm not sure I got them all, so we may have to add some more in here as we go.
Your Honor, I think we've removed the domestic violence recitation, so the cohabitant and direct definition isn't needed anymore.
Yeah, it was unclear to me. It was a sentence that I read regarding counts 1 and 2 as part of the reading of the information, but we can take it out and just proceed as if it doesn't matter. What's the state's position?
Your Honor, I know we didn't pull it as, I guess we pulled it by agreement as an element of the offense, not as a sentencing enhancement.
Right.
So I think the status quo is the parties agree that if the defendant is convicted of counts 1 and 2, that there is the DV sentencing enhancement automatically.
Right. That's right. It goes to sentencing, not to conviction.
But don't we need the jury to specially find it beyond a reasonable doubt in order for me to rely upon it at sentencing?
Yes.
Yeah, I think that was part of the stipulation, is that it is just a stipulation of finding.
Okay.
The court's going to be able to find that, Your Honor. They were cohabitants.
Well, I just need a waiver of Ms. Richins' right to jury determination on that, and then I can make the finding afterwards if that's how you want to proceed, or you can just stipulate to the fact now. I genuinely don't remember what we did with this prior to opening statement.
We do not want the issue of domestic violence in any way to be considered by this jury because it has not been addressed. It's too confusing.
Okay.
And in return for that, we agreed we would not challenge that they were cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that.
Okay.
at sentencing.
May I put it in my language and to see if you're comfortable with it?
Yes, sir.
Ms. Richins has the right to have a jury determine whether she and Eric Richins were cohabitants beyond a reasonable doubt. Is she waiving that right and submitting that issue to the court
She
for
is.
determination by the bench?
She is.
Well,
Okay.
It's gonna be pretty
Ms. Richins,
difficult
do you
not to
understand the rights
find
you're
it.
giving up?
Yes.
Okay. Are you waiving those rights knowingly and voluntarily?
Yes.
Okay. I accept your waiver. Find it's knowing and voluntary. On that basis, I'll remove any reference to cohabitant throughout the instructions. Agreed, Mr. Bloodworth?
Yes.
Or Mr. Mercer, sorry. Ms. Nestor, any objection?
No, Your Honor.
Okay.
Okay, is this, Fred, Mr. Burmester, is this definition of attempt
Yeah,
the same as yours
that was added by the court before I ever
before you
got a
did this?
chance to ask him to include it. It appears to be the same thing, so.
Okay. Just one moment, Your Honor. Can I just compare something just very quickly on the
Yeah,
attempt?
we'll need to take a break, so put a pin in it if you want. And-
It just will take me
Okay.
1 second. Okay. All right, so we can just toss this, right, Mr. Burmester? We can
Yes.
throw this out.
Yes, absolutely.
Okay,
That is-
all right.
I think
No
we're
objection to the rest of the definitions instruction.
From my latest.
Or to
short
number
with
40,
regard
which
to
comes after it.
upper
Thank you. Mr. Bremer, is there any objection to page 40?
No.
All right. That brings us to pages 41 to 42. Elements of criminal homicide, aggravated murder, count 1. It is the italicized language that represents a addition or proposal by one party or the court.
So the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really married to how we address it. But I think you know where I'm going with this. So there is testimony that has come in, or evidence, either testimony or documentary, that could let a jury find that Ms. Richins purchased oxycodone, thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it. My concern is if the jury thinks that under that circumstance, it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It could be a lesser included offense. So I don't know how to carve out. It's my reading of this statute and the information that in order to convict Kouri Richins of aggravated murder, which is this count, they have to believe that she knowingly and intentionally caused his death. If a jury is confused about whether knowingly and intentionally causing someone's death means buying something you think is oxy, giving it to someone and it's actually fentanyl and they die, that's a problem.
Well, pause for a minute. Let me ask you some legal questions.
Right.
So I acknowledge that you tell me.
Okay.
I'm learning about this in researching these instructions and seeing your
Thank you,
proposed language.
1016 Debs.
Assisted suicide manslaughter is a crime with specific elements in the state of Utah, right?
Right.
Under 76-5205.
Right.
If, for example, a defendant in a murder case wanted to request a lesser included offense based on this factual theory, they would have a basis to do so because that lesser included exists.
Correct.
That's not the same as saying, though, the state has to disprove that alternative beyond a reasonable doubt. It's not an affirmative defense.
Right.
I agree with that.
So I don't think I have to include that language in the elements. The real question is whether you're asking for a lesser included or I mean, you could certainly argue to the jury some
That's-
factual inference that,
Yeah.
listen, there's an inference to be drawn here that she got this stuff for him because he wanted it.
Yeah.
that line of reasoning or doubt.
So,
But I don't think the state has to affirmatively prove without a reasonable doubt that this isn't assisted suicide manslaughter.
so I think that the state has to prove it was a surreptitious administration. And I don't know how, I don't think it's enough if she administered it by handing it to him and he said thanks and ate it and died. So I don't know how we address that with the jury.
Does that follow from the elements in the statute?
It says by the administration of any substance, and it doesn't say, I
Doesn't say
just don't think that's
surreptitious.
aggravated murder. If she administers it by handing it to him and he says thanks and eats it, that's not aggravated murder.
What if he doesn't know
Well,
what it is?
I'm going to create a very morbid and dark hypothetical.
This is all morbid and dark, so,
Imagine a healthcare provider
right.
says to a patient, would you like some morphine to help with your pain? They say yes, and then pushes the plunger way too far intentionally. I think that's
there's an
still
intent to
aggravated.
commit. That's an intent to commit, cause
To
a death,
cause the
though.
death, yeah.
Right. But we've got witnesses of the state coming out talking about you can be fooled by these pills. I mean, they put that testimony
Yeah,
out,
but that's a
right?
different element, right?
Thank
You're
you,
down
thank
on
you.
4B. I mean, I'm down on 4B. Intent to cause is up on elements 1, 2, and 3. We're talking about the how, not the intent. The intent as to the result is the top level. That's homicide. It's the aggravating circumstance that's 4B.
That's right. I don't even have to see the language to know that's
Let me
right.
pause there. I'm carrying a lot of water here. Does the state see it the same way?
Yes,
Okay.
yeah.
And Your Honor, this, from reading the tea leaves on how the facts came into evidence in this argument, the state is concerned that the state is concerned that the defense will not be precise in arguing the intent in closing, right? The evidence has come in, and this discussion here today has suggested that the defense is putting the intent on a specific drug to kill, and that's not where the intent lies here.
No, but would you acknowledge that if the defense were able to persuade the jury, for example, that Kouri Richins intended to give her husband a non-lethal dose of hydrocodone, that would be a permissible basis to argue that she is not guilty of aggravated murder?
That is a permissible basis to argue she's not guilty under the second element of aggravated murder.
Why not the first, second, and third? She didn't intend to cause his death. She intended to give him non-lethal painkillers.
Well, okay, second and third together.
Yeah.
You know, we've split them up here sometimes. They're in the same sentence. It's really weird that we split them up.
Right.
But the second and third together,
Right.
sure, that is fine. But intent is not an element of 4B. Like in
Agreed. Oh, I agree.
I actually agree with that too. I was just trying to figure out how to deal with this scenario and not have a jury. I guess we'll just focus on intent in the argument.
Yeah, it's intent to
Right.
cause a death. Intent to cause a result, that's where the intent lies. If you intend to cause the result by means of administering what you think is fentanyl and it turns out to be hydrocodone and it's deadly either way, doesn't matter. Or vice versa.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
I agree with
I
that.
think we're all agreeing.
I agree with that.
okay, can we put 2 and 3 into one sentence?
We can. We typically don't in Utah because we want to make sure they separately, unanimously find beyond a reasonable doubt the culpable mental state.
I also think there needs to be a separate finding of causation. I think they should be apart.
So, I mean, this is the way the elements instructions under Mucci typically work.
Yeah.
It's confusing.
You can send a strongly worded letter to the Muji committee, but I'm going to stick with this for now. But we're going to strike. Let's just go down the page here. Mr. Burmester, did I cut you off there?
No, Your Honor.
Okay. We're going to strike the language without the knowledge or consent of Eric Richins, because the court rules as a matter of law that language does not represent an element of the crime or an affirmative defense that the state has to disprove beyond a reasonable doubt. Okay. Then we get to the extra italicized language, of which I've provided two versions. One more elegant than the other, and the more elegant one isn't mine. But rather than have a separate instruction for jury unanimity, one offense in two ways, I thought we'd just include the operative language here. And all we need to do is expressly instruct the jury that there are multiple ways to find that this was committed beyond a reasonable doubt, but you've got to agree about which one of the two aggravating circumstances you believe the state has proven.
That's 100% the law. That is correct.
Yes.
The reason why part of this is coming up is because the claim is aggravated.
Right, because I was going to say, I thought we did this, but you're right. We put it in a separate instruction. This is much better to put it in the element instruction, I think. I like it better.
Let's be clear. This was Melanie's idea.
Yay, Melanie.
Yeah.
And for aggravated
So
murder, they
we're
have
talking
to
about the
find.
top.
So you've
One
got
with A and B,
you got
right?
two options here, right? You got the more wordy option before the or the more elegant version after the or.
To find aggravated murder, they have to find an aggravating element, which is what they're talking about. But the aggravating factor,
I think the top one's clearer. Even though it's longer, it's clearer.
Oh, you're right. I'm sorry. We'll put reason instead of motive in there. Good catch. So, Ms. Nestor, if we were to see in the top version, instead of saying for the motive of pecuniary
It's
gain,
not
may
an
we say
element
for
of-
the reason?
it's not an element of murder.
Yes.
But it-
And I think you also have motive
In the very beginning.
in the first sentence.
Yep. The reason or means.
but it's.
You know,
the
as we do this,
factor
though, I'm
that
kind of leaning towards the second version.
Your Honor, the state does too. I also think we need to account in the second version for the possibility of finding both. I mean, you say at least one,
Right.
but there, I think in the next line, and you must unanimously agree which circumstance, I think we parenthetically plural it.
You want to say which or both?
Yeah, something like
Okay.
that. The state has proven.
Yeah, we can do that. Do you want to say which circumstance or circumstances the state has proven?
Yes.
Or just put a S in a parentheses, so it could be either.
What's that? Yeah. We'll just say which circumstance or circumstances. We're going to go with option 2, Ms. Nestor, notwithstanding
Okay.
the time I wasted on option 1.
The aggravated circumstance is what makes the murder an aggravated murder.
Okay,
and
pause
so
there
it
for a
has to
minute.
Find
With
unanimous.
I'm just going to read it out loud. You tell me if it hits the ear correctly.
Okay.
To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt, and you must unanimously agree which circumstance or circumstances the state has proven. If you find the defendant guilty of aggravated murder, you must determine, we'll get rid of that sentence. Got it, thank you. And we'll just we'll mark your decisions on the verdict form. Okay. Ms. Nestor, anything else there?
But in order to
Just a
get to
moment.
that, they've
I'm
had
getting
to
a
find
text. I just want to
murder.
make sure I'm listening to my co-counsel here.
And murder would be the intent to kill and causing the death. Thank you, 1016.
Okay, no, that's fine, Your Honor.
I really appreciate
Okay.
it.
I will make similar changes to the elements of count 2. So we'll get rid of the italicized language in element 4. we'll strike the inelegant option 1, and we'll get rid of the reference to cohabitant. And then we'll add the or circumstances.
Okay.
ABCD puppy,
Okay.
LMNO puppy.
With
I don't
respect
think
to the
anybody will
definitions
throw
of mental
anything
state.
at you.
Murder is one of the, or homicide is one of the rare crimes where it is a result-based crime, not a intent or action-based crime, right? Notwithstanding your best efforts, if you don't kill someone, you did not commit homicide. So the mental state definitions have to be specific to counts 1 and 2, and they are different, I think, than counts 3, 4, and 5. Is that the state's view of it?
3, 4, and 5 are not the
Certainly
murder.
with regards to 1 and 2.
They're the
One
financial
would think this is
ones.
a super easy thing to figure out if
It is
something
not.
is specific or general intent crime.
Yeah.
And I've struggled with it for 30 years. Maybe that indicates I'm stupid. But I have no objection to proceeding with the way the court is laid out.
Okay.
Right, 'cause
The mental states
Intent.
definition on page 46.
Right, I think initially, the ones we submitted, Mr. Burmester had actually put it on the bottom of the counts, and it was, I like this better, separate. I don't know, I always question whether jurors ever understand this, but I think this is the best shot we have at getting it to them.
Yeah, in fairness, I should probably move mental state defined counts 3, 4, and 5 to after.
After you
The
give the elements
instructions.
instructions, I think
So-
that would be better.
But while we're there, Mr. Burmester, I understand you to say no objection to pages 45 or 46. Is that correct?
Correct.
Okay. Ms. Nestor.
So you're going to move what's on page 46 behind the elements instructions for 3, 4, and 5.
Correct.
That's better, I think.
Okay. Any other objection?
Just 1 second, Your Honor. I think this is the same language we had.
I think generally.
Yeah, no other objections to that.
Okay.
And maybe not easy, but not difficult. I don't know why it took them 30 years.
All right. I have lots of questions regarding elements of 3, 4, and 5.
Yeah, so do I.
So I got to pull the information. We got to look.
These
at
are the financial crimes now. 1 and 2 were the murder, the aggravated murder, and the attempted aggravated murder. The March 4 killing and the February 14 attempted killing. Now we're going to the money crimes. Remember, most of these are charged in another indictment and another case, criminal case
Felony,
against
not
Kouri
anymore.
Richins. But these 3 are here in part because they help to explain.
All right, so let's focus on
murder.
count 3 for a moment. It's insurance fraud, allegedly committed somewhere between January 29 and August 31. It is charged under Utah Code 76, 6, 521,
D.
2D, right?
Yes.
All right, so let's start with couplement mental state. Because the statute does not specify a mental state, it's intentionally, knowingly, or recklessly, correct?
Right.
But it says it
That's the
specifically
Penal
in
Code.
Part D.
Oh, with the intent to deceive or
It's
defraud.
a specific intent.
Oh, there we go. Yeah, so this is where it gets confusing because 2 says with intent to deceive or defraud, and then 2D says intentionally, knowingly, or recklessly devises a scheme. So different intents for different parts of the elements,
Right.
right?
Yeah, okay.
Okay.
Yes.
Devises a scheme or artifice to obtain ... anything of value by means of false or fraudulent pretenses, representations. So, 2 questions here. I don't see from an insurer anywhere in the statute.
Agreed,
May we strike that language?
yes, from the state.
I mean, I don't want to add language in, so
Okay.
that's fine.
So we'll take that out. And then Ms. Nestor, in your submission this morning, you make reference to 2D's
Right. Let me pull that.
phrase, fees for professional services.
Right, so I read this statute differently than the state does. I think they're trying to shoehorn a crime that is a different crime under the statute. I think if you read the plain language of the statute, taking out fees changes the whole nature of what this crime is. I think this is actually not the proper crime that they meant to charge, but now that they've charged it, I think they have to do it as written.
Well, tell me why subsection 521-2D doesn't read as follows based upon its plain language.
Hold on, Your Honor, can you give me 1 second? I had to pull the statute up on my screen.
No problem.
Just let me catch up just a minute. Okay. There's something going on with here. All right.
Excuse me.
Okay, there we go. All right, just a minute, Your Honor. 76 6 Here it is.
The numbers that you're
Okay,
hearing
I'm with you. Please continue.
are
All right, so
references to the
521-2, an actor commits a fraudulent insurance act if the actor with intent to deceive or defraud does one of a number of things, but as relevant to this case, D, intentionally, knowingly, or recklessly devises or scheme or artifice to obtain two categories of things in the alternative: fees for professional services or anything of value, and then by certain means. Why doesn't it apply equally to two alternative categories of things?
I read that differently.
Okay.
And this is the fun part about, plain language, right? So I read it to say that this is the crime for when someone is pretending to be to get fees for selling insurance fraudulently. That's what I think this section of the statute is. And I think the fees part applies to, it should be read to obtain fees for professional services or anything of value. In other words, I'm trying to get someone to pay me as an insurance broker by making false representations about what I'm selling you. I'm selling you something that's junk. It's not what you think I'm selling you. So I'm either trying to get a fee or have you pay me for the actual product that I'm selling you, but by means of lying to you about what it is I'm doing for you. That is what I think this is. And that is not anything to do with Ms. Richins. I think they liked the second half of that and pretended like the first half didn't exist. And that's how I read this crime, because that is a crime. There are people that I've represented them. They go around and they sell junk. They sell a policy that doesn't cover anything, and they get either a fee from you as a broker, or they get a commission, which from selling you, they get a commission of the junk product, and it's fraud. And that's what I think they're talking about in this crime. And I don't think it applies here. And I want the word fees in there because I think they picked the crime. They got to prove it as it's written. And they just deleted that word.
They're
Well,
reading
they're
the
not
clause
proceeding
differently.
under that theory, but it's in the alternative. I have to acknowledge the comma and then the word or. And I can't consider the word insurance in the title of the section. That's non-substantive. In fairness, I see that the word insurance appears in section 2, so I understand. I'm looking at the definitions, though, for the part
I wish they'd take
and
a
the
break so I could
definitions
explain
in
this.
101.5, and they don't define insurance. I mean, the legislature's got to call it something. They chose to call it this. This seems analogous to the statute for communications fraud, which really is fraud. Like the communications in the communications fraud isn't doing much besides
Or
requiring that somebody
system.
communicate something by speech, writing, whatever. I too wrinkle my brow at the inclusion of the word insurance, but it seems just to be a label that the legislature has used. The substance of the statute on its face says what it says. Are you aware of any reported decision limiting the scope of this statute?
I tried. I looked. I couldn't find this particular, because I just kept reading it over and over, and I'm like, this is what you charge brokers with. This is what you charge, scammers in the insurance industry with. That's this crime. And I object to taking any words out of it exactly as it's written, because I don't think they've proved this, and I actually think they charge the wrong crime. I don't think that applies to the next two, but I do think it applies to this one.
You'd acknowledge that even if we put it in, it'd be an or.
Well, depends how you read it. I mean, if you take out the words or anything of value, or
No,
it doesn't
I
make
wouldn't
sense.
take those out.
No. I'm saying for
Yeah.
purposes of trying to understand it in context, right? So like the initial part of this says intentionally, knowingly, or recklessly devises a scheme or artifice to obtain fees for professional services, comma, or anything of value. And their reading of that is that or anything of value goes back to a scheme or artifice to obtain. But I don't think that's right. I think it goes to either for professional services as their broker or anything of value, like you made them buy a product from you. And so I think they should have to say exactly what it says on here, and the jury's going to just have to figure it out. But
Okay, but even in your world, in your view,
yes,
I hear you saying it would be 1, Kouri Richins; 2, with intent to deceive or defraud; 3, intentionally and knowingly or recklessly devised a scheme or artifice to obtain
fees for professional services.
A,
Or anything of
3A, fees for professional services, comma, or 3B,
But that's,
anything of
Yes, and 3B.
value.
that's not how it's written, though, Your Honor.
It's exactly how it's written. I
No, it's-
just put the comma and the or in the same place.
No, you put a B in there, an A and a B, and I
I
think
knew
it's
that.
all connected.
She objects to 3B.
I don't think it's written that way.
Oh,
If
okay.
they stop, I'll explain this
Well,
if
then
you're
we
not
should
following.
take the 1, 2, and 3 out as well.
Take the, which one?
Never mind. I understand your point.
Yes.
Okay. Mr. Burmester, go ahead, sir.
If we're going to add the theory that we're not proceeding under, then it should be A and B, to make it clear, because it is an alternative. It's a
And
list
they
of
can
two.
raise it on appeal if she's convicted, and you'll get an answer from the Utah
I don't
Supreme
know how to read it
Court.
any other way.
If
Yeah.
that's wrong, it comes back, though, because that's not, these go straight to elements.
And the
Okay.
Utah Supreme Court will answer it,
So,
and then there'll be case law.
Mr. Burmester, any objection to including the language in the alternative form as it exists in the statute?
As long as it's A, alternatively A or B.
Okay.
I object to the A or B, Your Honor. I think it should be all one sentence, like exactly like it's written.
I understand your position. Okay.
Okay.
Let me give that
She's
some thought.
always going to think about it, okay. I could do this better if I had a piece of paper and could show you. Because this is a really technical argument.
Your Honor,
Mr. Ramos, go ahead.
just as you're giving it some thought, and I'm looking at 76.6.521, just straight from the code. An actor commits a fraudulent insurance act. I had missed it on, Your Honor probably didn't miss it. I missed it on the first one, but going back to the insurance act, that isn't in the instructions as it currently is, but just highlight it now as Your Honor looks at that.
Okay, thank you, sir.
Thank you.
All right. Very good. I've got a note there. We'll keep going. Regarding count 4, I didn't see any disagreement between the parties regarding the elements for count 4.
No disagreement, Your Honor.
Mr. Burmester?
Did we talk about element 4 of count 3? Because I'm not sure where that came from.
Oh, thank you. Yeah, you're right. I went too fast. I don't understand where that came from either.
I'm sorry, what? I didn't understand what he said.
Paragraph 4 of the elements on count 3
on
page
count 3.
47.
I'm sorry, I got to go back. Just 1 minute. I thought we were on 4. Okay, element. Oh, took a substantial step. That came from case law. That's case law.
Have the citation?
I did on the one that I filed. Let me pull that up, Your Honor. Just a moment. It's document 1584 on the docket. And wait a minute. Count 3. This is a different one. Let me see. I might have written it in my notes to the state. Just a moment, Your Honor.
I wish you'd take a break so I could explain
Oh, no,
this.
I don't think that came from me. I don't think that came from me.
It did not come from the state.
I think
Well,
it did.
so
I can
first
go
she was
back to
been
what you
arguing, said she had
emailed,
case
or
law.
from the parties, and was represented as, but it's not in the statute. Neither is the definition of insurer, and neither is the definition of substantial step. That's why we have highlighted
Oh,
those.
I know where this came from. Mr. Bloodworth and I had a discussion about the fact that the way that it was originally written, she wouldn't have had to do anything. She could have just imagined it and never taken an actual step towards the commission of the crime. And that language got put back in after we had that conversation. I think, and we were trying to fix that problem. And I think that was what Mr. Bloodworth added to fix the problem. I was the one that originally said the way it's written, she could just think about it and be guilty. She wouldn't have to do anything.
I think an act is kind of implicit in 3 by means of false or fraudulent pretenses, representation, promise, or material omission. I think that's the act here.
Well, I understand the point. It seems that the actus reus under 521 2D would be the devising the scheme, which I think is Ms. Nestor's point.
Right.
Well, if you devise it,
I could think of one
and
right
never
now.
say anything,
Right.
or do anything, have you violated the statute?
Right.
So what is the actus reus? What's the conduct?
By means of, and then those.
Well, but that's just a modifier on the scheme
Right.
that you've devised. I think the operative verb there is devising.
I do know in federal court law, it's clear you have to take a substantial step. I don't know if they just have an objection to the word substantial, but you got to do something. Something has to be done other than thinking of it in your head.
Why don't we just instruct regarding what the state's theory of the crime is?
Right.
And either they proved it or they didn't beyond a reasonable doubt.
That would be fine with me.
I mean, forgive me, count 3 is I get confused between count 3
It's
and
the
4.
scheme one with the $100,000 two-stage policy.
Yeah.
Oh, Genzo 33. Wow, thank you so much. I really appreciate it.
Application.
Yeah, the fraudulent, false or fraudulent pretense.
It's the submission of the application with the fraudulent stuff on it, right?
It's the submission of the application, but it could also be
Just signing
filing
it.
the claim as well, but yeah.
Okay, sure. Yeah. You could, yeah. We could instruct the jury that the state's theory is that Kouri Richins committed this crime by A, B, and C. I give it.
Or-
Yeah, right. Yeah. We'll take a break. You can all give that some thought. Maybe talk to each other. I understand your concern, but it seems that we don't need to be coy. We can just tell the jury
Yeah.
what the state thinks, and either the state proves it or they didn't.
Yep.
Okay, give that some thought. Okay. In terms of our initial review, let's keep going. Elements of count 4. Just read through that for me for a moment. Let me know if anything sticks out.
Well,
This I don't have an objection to, Your Honor. I think this tracks the statute and it also tracks the case.
Okay. Mr. Burmester, let me know when you've reviewed it.
On 4?
Yes, sir.
No objection, sorry.
That's okay. So then let's look at elements of forgery, count 5. 76-6-501. 2B1. An actor commits forgery if, with purpose to defraud anyone, or with the knowledge that the actor is facilitating a fraud to be perpetrated by anyone, the actor makes, completes, executes, authenticates, issues, transfers, publishes, or utters any writing so that the writing or the making, completion, execution, authentication, issuance, transference, publication, or utterance purports to be the act of another person, whether the person is existent or non-existent. This is the signing of the true stage life insurance application, signing of Eric Richins' name, allegedly, to the true stage life insurance application. Correct, Mr. Burmester?
Yes.
Okay.
Oh, there it is. You got it.
So we've got to keep with purpose to defraud anyone in there, right?
Yes.
Out of paragraph 2.
Yes.
Okay. But then, I think, if I understand what you submitted correctly, you're asking for without the authority to do so.
Right. That's right.
Okay.
And that's based, I decided the case law on that, state versus Gonzalez, state versus Collins, and I think the state has agreed to that.
Is that correct, Mr. Burmester?
Yes, Your Honor, that's an
Okay.
element that
Very good. So
supported by those cases.
2 and 3 stay in, correct?
Yes, sir.
Yes.
And then do we need to, can we skinny down 4 in any way to match the state's theory? Or
I don't know.
it's
if
just
we
the
have
way it goes?
Authentication. We may-
I mean, execute and authenticate don't really match the facts of the case.
Isn't execute just sign?
Yeah, because I thought execute meant make it effective, like, I don't know. And authenticate usually means notarize or something like
Yeah.
that. I still don't know what utter means.
Well, we can go back to page, any intentional act that puts a writing into circulation and implies by word or action that the writing is genuine.
I mean, it just seems like you could say make or complete a writing. or just make a
I think it's
writing.
make or utter.
Yes.
Make
That's
or
what I
utter.
think.
Utter's a weird word. Makes me think of a cow.
Mr. Burmester, make or utter, or make, execute, or utter?
Either of those two alternatives are fine for the state.
All right. Court rules that paragraph 4 should read, did make, comma, execute, comma, or utter a writing, so that the writing or the making, execution, or utterance purports to be the act of another person, whether that person is existent or non-existent. Do you want to take out the last clause?
I mean, we're dealing with an existent person, so
At the
it
time,
seems
yeah.
kind of pointless.
Any objection, Mr. Burmester?
No, Your Honor.
Okay. Got it. Thank you. Okay, pages 50, 51, 52, 53 are Muji second standard instructions.
I agree with that it is 50, but it certainly doesn't preclude one from arguing where two charges might be related factually.
No, certainly not. The state in its closing can start with count 1 and then pivot to saying you can consider the strength of the evidence regarding count 1 as part of your consideration of count 2.
Okay, I just wanted to make sure we're
What
not.
we can't let the jury think is that if they find a defendant guilty of aggravated murder, well, screw it. We're just going to click guilty on the rest.
I totally understand the rationale for it, but
Okay.
as I read through it, I was
Yeah.
kind of.
Okay. Page 54 is a edited version of what would normally come after as the second paragraph of page 53 to reflect that this verdict form has a lot more blanks than just 2.
Okay.
I'll take a look. You will see, please, the verdict form is separated into, I'm just going to say several sections.
To several sections.
Yeah.
Okay.
One section for each count charged. Any objection, Mr. Burmester?
I couldn't understand what you said.
No problem. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into, it currently says 2. I'll edit it to say several sections.
Okay.
Thank you,
No
Jen.
objection.
So 33.
Ms. Nestor.
Welcome.
No objection.
Okay. 55 is a Muji standard instruction. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
56 is a Muji standard instruction. It was part of the party's proposed inclusions pre-trial. I'd like to hold it in reserve so I at least have a place to start if the jury reports that they're having trouble reaching consensus.
Well, I just don't see the harm in doing, I mean, I think, I always want jurors to be instructed by the court, not just us, that they're not to surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of their fellow jurors or just to return a verdict.
I
just-
agree, and that's why you should look at paragraph 3 on page 51.
Oh, okay, did you stick it in there? I didn't see it.
No, it's just part of the standard overarching unanimity instruction.
This is in case
Oh,
the jury,
that's fine.
Recently had a
Reports
home
a
jury, I need a
deadlock.
place to start to apply gentle pressure to keep working, and this is something I'd like to have in reserve. Okay, so I'm not going to give this as part of the pre-closing instructions.
There is a typo
it's
in
only
it.
going to
Oh,
use it if
what
the
is it?
jury reports it's.
Third line from the bottom, do not surrender.
Thank you. Got it.
That's kind of an important section.
Yeah. Okay. All right. May we please And Ms. Nestor, we're going to come back to your submission here before I take a break.
Okay.
But let's go to the verdict form next.
Okay.
Fairness, this was the last thing I did before I came on the bench, and so there may be some typos or flow errors here, but let's just go through it one time as if we were jurors answering it to make sure that
Okay,
it
this
flows
is the verdict,
correctly.
what they have to fill out once they reach the consensus, once they're
Okay,
unanimous.
give me just 1 second, Anna, I'm sorry.
This is the one that caused the trouble in the first trial in Massachusetts.
Your Honor, I
The
don't,
first
well,
retrial.
unless it's at the beginning. I don't think I got a copy of the verdict.
I think it was in the email that I sent after I sent a copy of the jury instructions.
I did not receive that email.
Hold on, Wendy, I'll send it to you right now.
That is
Just
entirely possible.
Thank you.
No, you did. Or at least I sent it.
I didn't get it, but
let me forward
Kathy,
it.
maybe just
Okay.
resend it.
Yeah, I'll send it right now.
Thank you.
Okay. I just sent it.
I
Okay.
should say skip to count two.
Oh, we're gonna take out 1B. And so this has to change to right there. Count 2. So I'm gonna take out 2B.
Okay, now we're having a little difficulty with the feed. Yep, we're definitely having difficulty with the feed. We lost it. Nikki Combs, thank you so much for the gift memberships, and thank you on behalf of those who will get the gifts. I really appreciate it. It's very kind of you. It's very kind of all of you who give gifts. You don't have to, I know, and it really helpful to me. So thank you. I don't always get a chance to say it because I can't get words in while we're trying to listen to the trial. So there I am, but there's Kouri. Okay, we're back. Good.
Okay.
Oh,
Well,
if-
thank you, Ollie, in 1951. That's really generous of you too. Wow.
Okay.
I certainly
So let's see.
appreciate it.
Let's start with you, Ms. Nestor. So we'll take out the plural of inquiries and we'll say skip to count 2. There'll be no reference to 1B. We'll just omit inquiry 1B, right?
Right,
Same for count 2. Similar changes.
right.
Any other changes?
Yes, so I have some worries about it not being, I know we have an instruction on it that's separate, but I sure would like it to be clear on the form of the verdict about that it has to be unanimous as to each one.
Doesn't it say unanimously regarding each one?
It does, but you could be saying you unanimously agree.
Oh, I'm sorry. Are you under 1A?
Yes, sir.
Okay.
So let's say they checked both.
So rather than say check all that apply, if I put in parens, check all regarding which you unanimously agree.
That would solve it.
Okay.
That would be, that takes care of my concern. Because my worry would be they would mark them both and we would never know.
We lost the feed again. I wonder what's going on.
Unanimous on
Okay, we're-
each.
Okay.
At least we can hear.
I would suggest flipping those. So starting, if you mark not guilty, proceed directly to count 2, and then
Sure.
after that.
Actually, that does make more sense.
No objection from the state.
Got it?
Same on,
Remains consistent with the,
and same under
Earlier
count
question.
2 as well.
Got it. Okay. Then, before we take a break, Ms. Nestor, may I go through just what you've submitted this morning to make sure I covered it all, at least initially?
Yes, sir. Let me grab it just a moment. Okay, I'm ready.
All right, we handled the quote "without the knowledge or consent of Eric Richins"
Right.
language on the record. Changing her to there, I didn't see a spot where that would be a problem in these instructions, but
I think that only applied to the ones when Mr. Burmester had the definitions under the elements. I don't think it's
Oh, okay.
a problem anymore.
all right.
So it'd be so much easier.
Insurance
if we had a
fraud,
copy of
I
the-
understand your position, and I'll take a break and make a ruling on it.
Okay.
The forgery elements instruction, I think we've reached consensus regarding anything further there.
No, sir.
I've ruled on defendant's request for a different definition of what constitutes proof beyond a reasonable doubt. Any further record there?
No, sir.
Number 5. Why don't you have sufficient foundation pursuant to the witness credibility instruction on page 22 to make exactly this argument? I'm not sure this is a legal instruction so much as a strategically sound part of your closing argument.
I think the Portuondo v. Agard case opens the door for instructions like this. I do think there's nothing in the witness credibility that talks about this. And I believe in Portuondo it was used against the defendant, but I think this is an interesting issue. I mean, if you have a witness who has sat through trial and heard everybody's testimony before they take the stand, that gives them an edge. And I think a jury can consider that. And I don't think there's anything in our existing witness credibility instruction that addresses something like that. And I think we have a right to bring it to their attention and say, hey, if you want to consider that, you can, but you don't have to. And that's why we want that instruction. Because O'Driscoll was the last witness of the case. He had some very important testimony in this case, and he had the benefit of hearing 45 witnesses before himself and all the court's rulings on everything before and every out of the jury conference and everything. So I do think that's proper, and we are asking that it be given.
That's interesting.
Mr.
He asked
Burmester, I
him
certainly
because he was
understand
at
why the
trial.
defendant wants the instruction. Anything further on whether they're entitled to it?
The state disagrees they're entitled to the instruction. Portuondo didn't involve an instruction. It was exactly that an argument was made by the prosecutor about the defendant being present, and the court said that's just fine. That can happen in this case, but it shouldn't be an instruction from the court. It shouldn't. There's no basis for the court to give its imprimatur on O'Driscoll's
It's ironic
veracity.
anyway.
And,
Okay.
and can I just, before you
Sure.
rule, Your Honor, I am fine if you want to just take some semblance of this language and insert it into the witness credibility so it doesn't seem to highlight, as it being more important than any other thing they're supposed to consider when they're considering witness credibility. It's just one of a list. I'm fine with that too. So
Okay.
if that makes you feel more comfortable, I would do that as well.
I will, with the benefit of counsel's argument, take a fresh look at Portuondo versus Agard. After the break, give you a ruling.
Thank you, Your Honor.
Okay. I understand defendant's position regarding United States versus Garcia. Anything further?
No, Your Honor.
Mr. Burmester.
I just want to reiterate that Garcia closer fits this than their point number 11.
Understood. We took out the defendant testifying instruction. That's handled.
Right.
We took out the children testifying and the age of witness instructions.
Okay.
I've given the request for a re-emphasis of the burden of proof instruction. We have a 404B instruction. I need to just make a ruling regarding whether we'll be discussing motive as the other purpose or motive, plan, preparation, identity.
Right.
The other 404B purpose is listed in the rule. We'll come back on that. And then we've already discussed the in-custody informant instruction. I'll give you a ruling on that in a few moments. Anything further on that, Ms. Nestor?
No, Your Honor.
Ms. Nestor, anything further before we take a break?
The spoliation instruction.
You made reference to it in an email.
Yes.
Spoliation is a legal doctrine that has elements.
Yes.
You got to make a showing.
Yes. I understand that.
Okay.
Do you need a break, or do you want to just do it?
Let's
knock
take
it
a
out?
break while you
Okay.
get that lined up.
Okay.
But I, like some other rules, just saying the word doesn't necessarily get a party there. There has to be a showing. I have to make findings.
I understand.
So, all right, Mr. Burmester, anything before a break?
No, Your Honor.
Okay. 3:15, folks, please. Thank you.
Okay, let me go through some things now that we have a chance. First, that last argument about O'Driscoll having been in the court and heard everything, so she wants some sort of special instruction that says he heard everything. You should take that into account because essentially he could have molded his testimony because of it, or he had extra information when he testified. That particular claim by her is really rich because if you recall, when O'Driscoll was on the stand, she asked him all kinds of questions based on the fact that he had been in court that related to other witnesses that she did not want to call in her case in chief. So for her now to turn around and say, now we need an instruction which says you better pay close attention to him because he might have molded his testimony, I really think is rich. We'll have to see what the judge does with it, but that one amuses me, no end. The argument that they were having about, two, I think both the other defense lawyers are on Zoom. That's what I think I heard. It's not just Ramos, it's both of them. Three, the argument they were having about credibility, the jury is instructed on general credibility. It's told you don't have to believe witnesses. You're entitled to assess whether they've got a special interest bias, whether they were in a position to hear what they heard or see what they see. I don't know quite how Utah's is framed, but there's that instruction. What the defense wants is another instruction specific to Crozier and Carmen Lauber on the theory that they were in custody when they provided the information to law enforcement and or they received immunity. And she wants the judge to instruct the jury, you should pay particular attention to them because they have a special reason for maybe wanting to lie. And the defense says the general credibility instruction should be enough. Didn't say this, but it could. You know, all kinds of witnesses have different interests or motives, and there doesn't need to be a specific instruction here. In general, part of the argument they were making what would it be? Where are you? 3:00 in New York all afternoon, is whether you need an instruction on something or whether simply the lawyers can argue it. It's perfectly available to the defense lawyer, to Nestor, to get up on closing and say, you know, you heard O'Driscoll, but he was in court all day. You don't need an instruction to get to it. So part of the sort of the general context here is what is so important that you also need an instruction to the jury and what falls within what the lawyers are entitled to argue in closing. So those were, let's see, do I have another one? Oh, there was one other thing. The question that Joel asked about a political trial with Charlie Kirk. I would like to do that trial. I hope STS does it. If not, I may try to figure out how to do it independently. I'm a little curious about why we're calling it a criminal trial. It's a murder trial. The motive in this case is money, it appears. the motive in the Adelson trials is that the family wanted the kids in Miami where grandma was. The motive here may be a disagreement about politics, but those are all motives. The trials are murder trials. That's my own view. You don't have to agree with it, but I wanted to say it on the record because it is what I think, and I feel strongly about it. Okay. Now I'm going to try to hold something up and hope that you're not going to be able to see it. It's the screen. My screen is just too small, and I don't know if I can make mine larger so that you can see it. I don't run this, so I can't. I don't think I can do it. All right, I was going to try to show you this, and it doesn't appear that I'm going to be able to do it because I'm little and I can't do it. So you're going to have to listen. It's a little harder if I do it this way. But the statute says an attempt, and I'm taking out a lot of the words of the statute just to get to the nub of where the argument was. The statute says an attempt to obtain fraudulently either fees for professional services or anything of value. Okay. The defense wants to read that. Now I'm going to rewrite it to say either fees or anything of value for professional services. In other words, the defense says that second clause or anything of value relates to professional services only. So it's an attempt to obtain either fees or anything else of value for professional services. In other words, she says the statute is designed directly for brokers or insurance agents. The state says, and the judge was saying that, but he said he's going to go back and think about it a little. The state says the statute should be read to mean either fees for professional services, comma, or anything of value independent of professional services. So if you see the difference, the defense wants to say the statute is particular to brokers or agents getting either fees or something else that you wouldn't call a fee. And that's why she said it's not the right statute to charge Kouri with. The state says, no, it means either fees for professional services or it means you acted fraudulently to get anything else of value, but it doesn't have to be because of professional services. That's the argument they're making. And let me read you the way the statute reads again, because they've got two different versions of what the comma means in that second clause. The statute reads, the attempt to obtain fraudulently either fees for professional services, comma, or anything of value. And they've got two different views about or anything of value, whether it modifies professional fees or it's independent of the language of professional fees. So I hope that makes it clear, but that's where their argument is. I got it. We had a question in the chat that said, is this typical what they're doing here? Yeah, it is. Once you get to jury instructions, it's really important you get them right. I had a question in the chat saying the defense wants to do it to have a better chance of prevailing, of course, and so does the state. But the major issue, and certainly the judge's issue, is to get the instructions correct, because you don't want a reversal of a conviction if she's convicted because the jury instruction was wrong. And jury instructions, there are a couple of places that are most fertile for reversals of convictions on appeal. Jury instructions is one of them, and maybe the main one. And the reason is the jury has to be the fact finder, clearly. But if you give them the wrong legal rule, they may come back on the facts, but it was matched to something wrong. For example, if this wouldn't happen, if the jury was instructed, murder one means causing the death and doing it accidentally, when the statute says murder one requires the intent to kill. Okay, the jury convicts, but the jury was told murder one was causing the death and doing it by accident. It's the wrong legal standard. The jury did its job, but it applied the wrong legal standard. The standard was intent to kill. So it's going to be a clear reversal on appeal. Now, the one I gave you is ridiculous. That error would never happen, but it's illustrative of the kinds of problems that can occur. That's why they are arguing about things or being so careful about things. There was an argument about the reasonable doubt instruction in the part that says you have to have a firm belief. I think it was firm belief. That's how a lot of reasonable doubt instructions read, but it doesn't just say that. It's in, but even if you do, remember that, if you have a reasonable doubt, that still overrides. You get I give you and I take it away. I give you and I take it away in a lot of reasonable doubt instructions. So Nestor said that language is is being challenged in different states and maybe even in Utah. And the judge said, this is the pattern instruction that the Utah Supreme Court approved. It may be that someday the Utah Supreme Court would say, oh no, this instruction, it's not a constitutional instruction. But they haven't done it yet. I'm going to apply the reasonable doubt instruction that the court approved, period. Now, if in fact, and she said she wanted to make a record about it, the reason is if after, let's say Kouri is convicted, she's on appeal, the Utah Supreme Court gets this case, I don't think it'll happen fast enough, but let's assume, and says, you know what, this reasonable doubt instruction is unconstitutional. She wants to have made the claim on the record before the trial court, so she's preserved her claim that if the Utah Supreme Court says it's the wrong instruction on reasonable doubt, that Kouri's conviction has to be reversed. I think it would happen anyway, even if she didn't make that argument, because the reasonable doubt instruction is too important. But anyway, that's where they were. So she preserved on the record her right to claim that the wrong instruction on reasonable doubt was given in the event that the Utah Supreme Court takes a case and finds the standard to be unconstitutional. Now, there's a lot more I could say about this because it gets really complicated if she had not made the record, but she did. And I'm not going to go try to, go running around into law. We don't need to understand where the trial is right now. So Koringal Ron, oh, wow. Thank you so much. I really appreciate it. Okay. All right. Okay, uniquely Rubiella. Oh, welcome to Legal Scholar. Absolutely welcome. So I don't see any questions in here. And I don't even remember how long he said he was going to take the break because I was so intent in trying to get this thing written that you can't read anyway because I'm too tiny on the screen. Okay. Simone June 2143. Does the state get to have a rebuttal closing like in the Donald Adelson trial, or they just go last? I don't know how Utah does it. And I don't remember, what was the Utah trial? What's his name, who killed the four college students? I'm so bad on names. I just hate it. I've been bad on names since I was 5 years old, and I haven't gotten any better. I haven't gotten any worse, but I haven't gotten any better. He's got his, well, anyway, you're going to put the name in the chat in a minute, and I'll be able to get to it. But I don't remember how that went. In New Jersey, for example, the defense goes first, and then the state goes. In Florida, the state goes, the defense goes, and then the state has a rebuttal. In every Kohlberger, thank you so much. I knew somebody would come up with it immediately. In every jurisdiction, the state goes last. Whether the state goes last and it's defense then state, or whether the state goes last, it's state, defense, rebuttal state, the state always goes last. I've heard lawyers say they like the Florida way. I happen to like the way New Jersey does it. Defense goes first and then the state goes last. In openings, the state goes first because it gets the first chance to frame the case for the jury and give the jury a roadmap. It goes last because it has the last word on how the jury should see the case. And both those, going first in opening and last in closing, is because the state has the burden of proof. The burden of proof is beyond a reasonable doubt. It is the heaviest burden in law. You can't get a heavier burden, because the only heavier burden was absolute certainty, and that's an impossible one in life. So the state gets to go last. Okay, let's see. Okay. Vertus Gerford tells me that the state goes first, then the defense, then state rebuttal in Utah. And that certainly could be right. I don't know. Walk Away Renee wants to know if Sky Lazzaro's approach would have been different to the team Kouri ended up with. I don't know. I don't think so. Remember, at the point at which that Walk the Dog letter was written, she was investigating the possibility that Eric had purchased fentanyl in Mexico on one of the hunting trips, which is exactly one of the claims this defense is making. And that, I think, tells me that her defense would have been that Kouri didn't supply the drugs to Eric, that he got them on his own. Sounds like the same defense. Her style may have been different, but I think the substance of the defense, it seems to me, would have been the same. Okay. Phila 8 wants to know what the sentence is for aggravated murder in Utah. I don't know. What are the aggravating factors? They gave you the 2 aggravating factors. I'd have to go back to find them now. In the argument as to whether the motive to kill was 1, and the other was, let's see, did he read them to us, or did he just say 1 was murder and the other was means? I think he gave us in general what they were. I'm not sure he gave us what the words were of each. So I don't know that I can answer that. I don't have the statute in front of me. But the argument that they were making there, you've reminded me at least of the argument, even though I can't answer the question specifically, sorry, is murder is the intent to kill and causing the death. Now you can play with it. It might be intent to kill, premeditation and causing the death. It might be purpose to kill, causing the death, but that's murder. What's being charged here is aggravated murder. And so now there are aggravating factors. You first have to find the murder, and then there are aggravating factors. The United States Supreme Court has said that any factor, whether it's technically an element or whether it's an enhancement, a sentencing enhancement, has to be a decision by the jury, and it has to be beyond a reasonable doubt. So the elements of murder, intent to kill, causing a death, those are the elements. The motive, let's take motive, is not an element of murder, but it's an aggravating factor, which would make this an aggravated murder that also has to be proved beyond a reasonable doubt. And they got hung up with how they were going to do that to separate it. It's not an element of the crime, it's an aggravating factor. And they ended up, I think, deciding, what did they decide? To take it out entirely because it was too complicated to try to word. I think that's what they ended up doing. I think the judge on the reasonable doubt instruction, well, we'll see. He said he was going to come back to it. It's an open issue. I'm not sure whether he said at the end he decided it, but we'll know when he comes back. The one he's really looking at is the one that I just talked to you about. Where does or anything of value fit? What does the comma mean? Is it anything of value as an independent way, or is it independent of anything of value a modifier or related to professional fees? So those are the 2 things. And I wish I could have put up the language. It would have been a little harder, because what I just did to you is what they're doing to us. We can't see the language of what they're talking about. And it would be so much easier if you could see the words. Okay. Julia Ballo says she hopes, or she would be a she, hopes I cover Blake Lively, Justin Baldoni. I'd like to, but that's a New York case, and it's not being broadcast or simulcast. So it's pretty hard to, it's impossible to do the daily coverage, the commentary. Okay. And then Teddy and Roger want to know, do I think they knew they weren't going to call anyone, and that is why they were fighting to the direct during the state's case, and we're going to examine some witnesses further? I think they may not have been sure, but they absolutely wanted to get in as much of their case on cross of the state's witnesses, so that were they to decide they did not want to have to put on a defense, they'd be in as good a place as possible. but I don't think they were certain what they were going to do until they heard all of the state's evidence. Okay, let's see if there's anything else. Oh, Fairfax has something off topic. Is it rude to ask why Eric was banned from hunting in the U.S.? His friend and partner, Cody Wright, talked about this, testified about this. And my best, I don't know if he was completely specific, but Eric had violated the hunting rules in Utah, and I think somebody in the chat correct me that he had killed an elk out of season, and he was reported, and Cody was called in by the authorities, and Cody confirmed that Eric had shot the elk, and as a result, Eric's license to hunt in Utah was revoked. And that's why he was going to Mexico, and that caused a rift in the friendship, at least for a while. That was one of the things, by the way, that I thought made Cody so credible in terms of what he was willing, that he was going to be truthful on the stand and truthful as to what Eric had said to him and what he knew about Eric, because he was willing to risk the friendship because he knew how much Eric liked hunting, because he told the truth to the hunting authorities when they called him in to confirm that Eric had breached the rules with regard to hunting. And I think it was that he killed an elk out of season, but somebody can tell me. Okay, Tara Wells wants to know, what are the limits for closing arguments? Can the defense bring in anything they didn't get in by not having witnesses? No. Closing arguments are the defense and prosecution talking about the evidence that was admitted at the trial and nothing else. Okay. Oh, he killed an elk without an elk tag. Now, I don't know what that means. Does that mean that he wasn't authorized to kill elks, or he didn't pay for the license? I don't know what that means, but it was a violation with an elk. That's the best I'm going to be able to do. Let's see. No, Sheila Brennan says, wow, banned from the whole of the United States. I don't think that's true. I don't think Utah has the authority. In fact, I'm sure Utah does not have the authority when there's a violation of a hunting rule in Utah to ban the person from hunting in New Jersey. Now, maybe that there are reciprocal arrangements, so New Jersey and Utah agree that if somebody commits a violation in Utah and it leads to a revocation of license, that New Jersey reciprocally will also revoke a license or not issue a license. But Utah unilaterally doesn't have the right to tell somebody in Utah you can't hunt in Texas because we've revoked your license in Utah. It may be that if you apply for a license in Texas, one of the questions on the application will be, do you have a hunting license anywhere else? Have you ever had your license revoked? And that may impact your ability to get a license in Texas. That's entirely conceivable. But let me say as a caveat, I've said before, I don't know anything about drugs. I also don't know anything about hunting. But I do know something about licensing. So it seems to me to be reasonable that Texas would inquire if you've had your hunting license revoked, just as if you apply for a driving license in a state, one of the questions will be, have you had your license revoked in any other state? And that will affect their decision whether to issue the license. Okay, so Agent 47 says you have to pay for a tag and then you can hunt for an elk, and he apparently didn't pay for the tag. So it's like driving without a license. You drive without a license and you may have your license revoked for 6 months for that. So it sounds like the same sort of thing, but now I'm relying on the people in the chat. Jane Thorpe 4968, thank you for becoming a member. Welcome, Crawford. That's wonderful. I'm so pleased. I hope that what we do for members you will like. I'm doing some shorts, videos that have been specific to members and we've not made public. And we have a meet and greet about every 4 weeks that's for members. And, their badges and other kinds of things. We're probably going to be adding to what are members only opportunities. Okay. Let's see what else. I don't see any other questions, so I'm going to turn off this for a minute or two because I don't remember what the judge said about when he's coming back on, so I can't. But, you're going to hear it when the judge goes on, and so will I. So see you shortly. Okay, I'm back, and it looks like a number of you are still in the chat. Auto 1630 put a message in the chat. Thank you so much. Saying there's an interstate wildlife violator compact. Interstate compacts for those states that agree to participate say that a violation in one state will be recognized in another state as though it were their violation. And so there is one that governs wildlife. And among the provisions is that if there's a violation, let's say in Utah, then any state that has signed on to the compact agrees to recognize that violation and treat that suspension in their state also. Now, what that effectively means is if Eric had not had a license in Texas and went to Texas, they're not going to suspend their license because he's never gotten one there, but they won't let him apply and get a license in Texas for the period of the suspension or revocation in Utah. So there are a lot of, as I say, there are a lot of interstate compacts, and they're reciprocal. A state does not have to sign on to an interstate compact. So there may be states that never adopted the Interstate Wildlife Violator Compact in the United States. And so Eric could go hunt there because there is not that statute. At least there's no requirement. It's still possible that if he went to a state that didn't sign on to the compact, but he reported that his hunting license had been suspended in Utah, it's still possible that the state would say, we're then not going to issue a more license. Not because they've agreed to the compact, but because their own rules say they're just not going to do it. But in any event, thank you, Auto 1630, for letting me know that there is an interstate compact. Okay. Phila 8 wants to know why the state didn't make Kouri's mother and brother testify. I think the state felt that they would be hostile witnesses and it would not get much out of them. And therefore it wasn't worth calling them. And that on cross, the defense might have gotten some positive information out of them that would have helped Kouri's case. IMU 1896 wants to know if summations have begun. I think they'll be on Monday. Right now, they're still working on jury instructions. Tara Wells, didn't you already give me a gift? I'm pretty sure you did already. Thank you. This is way more generous than well, I don't know what to say then, but I am very, very appreciative. Thank you. Wild guess how long the jury will deliberate. I'm not doing a wild guess. Yeah, I actually, on the Adelson stuff, I guessed right twice. I really thought they were going to be short verdicts both times, but this one, I think the jury, because they've got those 3 other counts, and I'm not sure, the ones that are not the aggravated murder, the attempted aggravated murder, and it may be that the jury will, since they're so different, may take some time with them. And I do think, particularly on the attempted aggravated murder, that it may take the jury a little time to work out whether they think the case is proved beyond a reasonable doubt. But Hun Lover 3 is willing to guess at least 4 hours. Scotch Mom said 2 days. IMU 1896, thank you very much that this is definitely the channel to follow during trials. I hope more people agree and, I get more people watching. But STS does a good job too. And right now, STS is very accommodating, letting me sort of tag on to their stream, which is really very, very, very nice. Okay, let's see if there's anything else in here. I don't see any other questions in here, and I don't know whether the jury, not the jury, I don't know whether the judge is longer than he said he was going to take because I neglected to write down what he said. Or actually, I didn't neglect to write down what he said. I didn't listen to what he said because I was so intent on writing this, the statutory language, the instruction language with regard to count 3 that I couldn't put up anyway, that I wasn't paying attention, I'm sorry to say. Oh my, Janet Thorpe, just $50. Wow. That's really generous. Thank you so much. So wow, I don't know what else to say. I'm speechless almost. Thank you, thank you. He said he was coming back at 3:15, so he's 10 minutes late. Thank you, Stella Bella. Thank you, Simone Juno. Thank you, Jersey Red. So I've got 3 people telling me 3:15 and he's not here. Okay. Miami Dottie says the verdict will come in Tuesday. We don't know what time on Monday it will be submitted to the jury, but she thinks it'll be Tuesday. Phila 8 wants to know if I'm having a working holiday in Italy. Well, yeah. I mean, it can't just be a holiday because I'm doing this. And although I enjoy doing this, you know, it's not vacation solely. Coron Gill wants to know if I visited Milano. I have visited Milano, but not on this trip. I am in Sorrento, and I have gone to Pompeii and to Ercolano and to Positano, and I'll be going to Capri and hopefully to Salerno, but I'm not going any further. I'm going to stay on the Amalfi Coast. Okay. Why am I always, Pam White wants to know, why am I always in Italy? I'm not always in Italy. I get here maybe twice a year, but long stays. Okay. Scott's mom says, no, it's not Scott. Hunlover 3 says 3:15, but maybe he'll be more loose because there's no jury. Well, he wasn't making the time all the time, even when the jury was there. So I guess I didn't answer the question about why am I always in Italy. I just said I'm not always in Italy. I like Italy, and I'm learning Italian, and it's more structured if I'm here when I'm taking Italian lessons. So that's what I'm doing in the mornings. Okay. Italy sounds so beautiful. It really is. Really is. And some of the shorts that I'm doing for members, some of them we're doing publicly, but some for members are, you know, showing some of the places around here. Sorrento is really beautiful. Capri is gorgeous, but very expensive, says Virtus Girl Fur 5069. Yeah. Well, you know, very expensive compared to what? New York is more expensive than Capri, I think. Sorrento is just really beautiful. It's not all open yet because the season hasn't started. So there are a lot of stores that are not open. There were a lot of restaurants not open. Things are starting to open now. But I was at a restaurant along the water today for lunch, and there were, I almost took a short of it, swimmers in the water, which I could not believe because it's still about 55 degrees here, maybe 60, and the water has to be a lot colder because the water is going to retain the cold longer. And I could not imagine, just couldn't believe they were in the water. But then I'm always cold, so, but it was just striking to me. Okay, Rhonda Hyde wants to know if Kouri is found not guilty on all the charges in this trial, will she be in custody pending the financial trial? I don't know the answer to that. Very often for crimes that are not violent crimes, defendants are on release until the trial because the bail rules are you should be on release unless the crime is violent and there's a risk that you're going to injure someone, reoffend violently, or there's a risk that you might flee. And so those two things are much more likely in a very, very serious crime where there's a long prison term that might be imposed, and much more likely with a violent crime that you might be dangerous to others if you're on your own than if they're simply financial crimes. Okay. So Corin Gill is now using her Italian, Agordi Imparati Italiano. So I hope so. Thank you very much. Okay, let's see. Oh, thank you, Leigh. You've been boosting the public shorts. I really appreciate it. Those hypes, you get 3 a week that you can use, and I'm selfish enough to say I'd love them all, but even one would be nice. The algorithm pushes up channels or particular videos if they're hyped. And I said once before in here, if you, for example, if you're looking to get a vacation house somewhere and you Google it, some of the travel sites come up first, and that's the algorithm that's being used. You may have to dig down to find other travel agents or sites that you can use. And obviously, if you're up at the top, you have an advantage because people might look at it and, go with you without digging down into the list. So that's what the hypes do. They help. So do the likes. Oh, Hundlover3, thank you very much. I really appreciate the gift. So nobody is saying gelato or espresso or Prosecco anymore. And I thought we were having a contest to which you really wanted me to drink or eat. I did. I'll tell you about what I had today if I didn't already. Maybe I did. I did a short on it today. Jerry Michael, thank you very much for the gift. You feel like you're in one of my classes. You should talk to students who have been in one of my classes, and they would say, you don't feel like you're in one of my classes. I was at this wonderful restaurant. Oh, thank you, Leo Ren. Thank you so much. I was in this wonderful restaurant today on the water, gorgeous scenery. And at the end of the meal, people were ordering, desserts and cafe. And I ordered a cafe. And then I thought, I think I'd like a cafe affogato. And cafe affogato, they do it 2 ways. Either it's a cup of espresso and a little dollop of gelato, or it's gelato with a few, maybe a quarter of a cup of espresso. And I thought the context was clear to the waiter that since I switched from an espresso to a cafe affogato, that I wanted the coffee with a little bit of gelato. Well, instead, this it was very big gelato with a little bit of espresso. And I like ice cream, and I'm looking at this thing. I made everybody at the table share. So everybody took some, and there was still some left. It was very good, I must say. But it wasn't what I had planned to order. Okay, let me see. Any questions? Jumping ahead here. Do I think Kouri will make an allocution or preserve her appellate rights? An allocution is when you plead. So if she's convicted, there isn't any point in which she's going to make a plea. Okay, Tara Wells, is that enough? Oh, good heavens. You just gave me another $5 for a gelato. Wow. Good heavens. I think it's getting too late where you are, and you're just getting too free with your wallets. You have a whole week to get through. Leo Rain, you had a question in your $5 gift. Let me see if I can. Oh, you did. Okay, let's see. Do judges always limit the amount of time for each side in closing? Absolutely not. If you had watched the Canero trial, you would know the answer to that because both those closings went forever. And I had on one of my lives when I was in the States. I haven't been able to do them here because by the time the trial is over, it's midnight here. I'll get back to them when I'm back to the States or maybe when the trial is over. But I had on, and now, I keep telling you I'm bad on names, but he's a very, very prominent and well-known defense lawyer. His daughter just was one of the defense lawyers on the Sean Diddy Combs trial in New York. And anyway, and Mark Garagos. And I asked him because I was so amazed at the length of the closings, what he thought about closings that went, I think one of them went 4 hours, and he said, he did closings that were 5 hours. And I was even more amazed. So yes, closings can go longer. Time limits are dependent on the sort of really the style of the particular jurisdiction and also what the judge will permit. In Florida, if you recall the Adelson trial, the last one, Donna's, I think Judge Everett gave each side about an hour. And that included for the state, their opening, closing, and their rebuttal closing. So it's, and I don't know, I'd never encountered such long closings. And I actually, I didn't do a lot of prosecuting. I took a sabbatical to prosecute. And then I used to, summers would go back, but I only did one trial in the summers. After that, I did more training of investigators, and I did a couple of appeals. But I talked to some of, my friends who did a lot of trials, and none of them did long closings. So, but there are long closings. Clearly, those of you who did Canaro with me know that to be true. Okay. Have I ever studied Darrow's 11-hour closing for Leopold and Loeb? No. I read a couple of books on Leopold and Loeb, and some on Darrow. Darrow, there's probably pretty good evidence that he had acted unethically in at least one or two trials, including maybe that one. And he justified it. He never admitted it, but it was justified because he didn't believe in the death penalty. But I didn't see the 11-hour closing. But that was a different time. I mean, closings 100 years ago were longer. So were appellate arguments. And now you get 20 minutes, half hour at most. Okay. Okay, Tara Wells thinks the judge had too much gelato and is taking a nap. If he's taking a nap, he might well have had too much Prosecco. That would be more likely to bring somebody to a nap. Oh, Jersey girl in Idaho. Welcome to Legal Scholar. Absolutely welcome. So did anybody double check? Is this judge from New Jersey? He made that reference to New Jersey yesterday. But he's a skier, so I'm sure he likes Utah. We have little mountains in New Jersey, but they're not really, you can ski, but for real skiers, they're not ski mountains. So, but you can go up to Vermont, where they've got Stowe and mountains that are more ski mountains, but probably still not like Utah. Angela McCartan said Judge Everett was an hour apiece. That's what I think it was. Okay. Athena 0616 says the opinion of long deliberation because of multiple charges does confuse the jury to have to deliberate on so many issues. Well, here it shouldn't, because the charges are really pretty precise and different. They don't lap over into each other. I mean, the aggravated murder charge is the March 2022 event. The attempted is in February, and then you have the three crimes that are financial, and they may have a little trouble separating the evidence that goes to one as against the other. But generally, that's a benefit to the state, because evidence may be admissible for one crime, but it wouldn't have been admissible for another, and the state gets it all in. So generally, when you've got multiple charges, the state is helped. Ephraim Notes, thank you so much. And Ephraim Notes is talking about the 2016 pill bottle that in the house of an addict would have been long gone. So Ephraim Notes thinks it was a prop to stage the scene. I don't think, you may be right, but I don't think, or at least I have some question as to whether she thought she'd ever be caught. I don't know that she thought there would have been an autopsy and that the drugs would have been found in Eric's system. But thank you so much for the information and for the gift. Okay, so .u forum also thinks the bottle looks staged. You could be right. I mean, none of us know for sure, and Kouri isn't. Eric can't talk, and Kouri won't. Oh, he did say, I'm from there. Okay. This is 1024 DP, said the judge said he didn't know why he was picking on New Jersey. He's from there. Well, and so did Joel yesterday start picking on New Jersey, and he's from there too. So, but he also says a lot of good things about New Jersey. Okay, Sheila Brennan, am I traveling with a group or solo? And she's really enjoying the shorts of Italy. I'm with people here. Okay. Okay, Leo Wren said she was foolish to think there would not be an autopsy of a young man without health conditions. I agree, but some of the other things she did, you couldn't call very sensible either. And she didn't know, this is .U4M, she didn't know he'd changed the trust. She was angry. That's certainly true. Oh, I see his head. We're back. We're ready to go. I'm so pleased.
Okay. Mr. Burmester, do we need to wait for Mr. Bloodworth?
No, Your Honor.
All right. Let's, Ms. Nestor, go back to your submission this morning. We'll use that as a list here. First, with respect to defendant's request for an instruction or addition of an additional section to the witness credibility instruction regarding Detective O'Driscoll having had an opportunity to listen to all the prior testimony, and that instructing the jury that they may consider whether that opportunity to hear prior testimony enabled him to tailor his account when determining his credibility. The court has re-reviewed Portuondo versus Agard, 529 U.S. 61, U.S. Supreme Court from 2000. That case stands for the proposition that it is not improper for defense counsel to make that exact argument during its closing.
Karen,
But
thank you
it
so
does
much.
not stand for the proposition that it's appropriate for the court to give that instruction as if it is a precept of law. So the defendant's request for a jury instruction to that effect is respectfully denied, notwithstanding the fact that you'll be free to make that argument. Anything further?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. Then let's look
No,
at
Christine, no, they won't get the
the
case
first
today.
2 pages of
We
the
have their
additional
closings first.
instructions that I sent out. Page 1 is a proposed instruction called informant. It comes from the 10th Circuit pattern instructions. Page 2 is a instruction titled immunity. It comes from the 10th Circuit pattern instructions. I propose that we use these 2 pages in this form, which are not specific to any individual, and use the pronoun they, in place of Muji second CR 415, which is the custody informant. Mr. Burmester.
The state objects to number 1, informant, because there were no informants in this case.
Thank you, Poppy.
Well, tell me why Carmen Lauber doesn't fit squarely within the first sentence of this instruction.
The reason she is providing evidence, arguably, for a defense might argue, is because she was given immunity, which is why I don't object to number 2.
Didn't she also indicate in her interviews, though, that she was doing it based upon her sense of personal accountability for having been involved in this situation?
Yes, but that doesn't make her an informant. She testified, both she and Crozier testified to the events they saw. Frequently, in many prosecutions, the government has to make a choice of who to charge and what to charge. And sometimes in order to proceed on one prosecution, you got to give up another one. And that's what we have here, is in order to to bring to bear what the government saw as the more serious crime, that is what the state believes is a murder, we had to have those eyewitnesses be able to testify. In order to do that, we had to provide them immunity. I don't think that makes them a fortiori an informant.
Draw the distinction for me. What would you see the informant as being?
I believe an informant is someone who is privy to some statements or some other source that's not directly involved in the crime. So, a cellie who overhears something that a witness or the suspect say. They don't know anything about the case other than what they've heard somebody say in the jail or at a drug deal or whatever. So that's, and I think that
I think there's a better definition than
recent
that.
experience over the last decade or so, I think the courts were very concerned with that type of testimony for obvious reasons.
Let me spin a hypothetical here related to the
I don't
facts of this
think that's
case,
the
but not
definition.
from the facts of this case to make sure I understand your position. So it sounds like if somebody heard Kouri, or somebody came to law enforcement and said, I have information that might be relevant to the Kouri Richins case, but if I give it to you, I need a break on my probation. And they work out some kind of deal. And then they relate that Kouri Richins, once upon a time in 2022, in January 2022, asked me for fentanyl. And I'm willing to testify to that effect. But if I do that, is that the kind of situation you're referring to?
If we alter that just a little bit, the defendant, whoever it is, told me something, they killed somebody, or
Right.
they shot the gun, or
Yeah.
whatever. That, I think, is different. That's not a witness to the crime. I think if the witness had said, the defendant said they bought drugs, fine. But if the witness is witnessing the event, I think that makes them, that's the distinction that I would draw.
Okay. I understand your position.
I think it
Ms.
should be
Nestor.
come forward rather than the police
We have
finding
no
you.
objection to the new informant instruction or to the making the immunity instruction just general. We're fine
He's
with
going to
it.
lose this one.
Tell me why you believe an informant instruction is necessary, though. There's no dispute regarding page 2, so we don't need to talk more about that. Mr. Burmester is taking the position that as a matter of law, it's inappropriate to give an informant instruction because, if I understand him correctly, Ms. Lauber and Ms. Crozier, in his estimation, simply do not qualify as informants. Tell me why you believe they do.
The reason, well, I think they're clearly informants. I don't understand the distinction he's making at all. They're people that gave information and got a deal out of it, whether, I just have never seen that distinction made in the past. So I'm not sure I understand his distinction. But the reason I think you need both is because the immunity instruction only deals with the motivation of the grant of immunity. The informant instruction deals with other motivations, such as to get out of drug court, to be able to send texts to Mr. Maynard instead of having to get, urine tests,
Travel to Nevada.
to make herself feel better because she feels guilty. All of that is not covered by, those are all benefits to her from providing information that can cause a reason to be suspicious. So I think they're both necessary. That's all.
I understand your position. May I ask you a different question? I don't understand the relationship between the first sentence and the last sentence of these these two instructions. They
just
seem
brought them
internally
out.
inconsistent. Now, mind you, they are the pattern instructions, and so presumably some committee of 10th Circuit lawyers has come to grips with this, but
That is the last sentence is dealing with the scenario where they find no other reason to find guilt
Right.
other than this person's testimony.
But isn't that exactly what the second sentence in the first paragraph is talking about?
Yes.
It can be. Oh, I see what you're saying. The second sentence. I was looking at the last sentence. I'm sorry. The testimony in a form of the law. Well, if you believe it beyond a reasonable doubt. That's what they're saying. They're saying that you can't, if there's no other reason for you to find her guilty other than this person's testimony, you need to believe it beyond a reasonable doubt.
Okay.
And that's why
All right.
that's there.
So you'd acknowledge that you wouldn't be able to say, well, you can't convict based upon Carmen Lauper's testimony alone.
No,
You'd
they
have to-
certainly can.
You'd have to add some
Right.
language to that statement.
Correct.
Okay.
Absolutely.
All right.
Absolutely.
Anything further, Ms. Nestor?
No, sir.
Okay. All right. Counsel, with the benefit of your argument and having had time to consider it during the break, the court finds that based upon its consideration of the evidence that has come in this case, specifically regarding people like Carmen Lauber and Robert Crozier, that it is appropriate to give the proposed instruction entitled informant that comes from the 10th Circuit pattern jury instructions that is indicated on page 1. In addition to the pattern jury instruction from the 10th Circuit titled immunity, which is on page 2 here, based on that ruling, the court will not be giving any version of model Utah jury instruction CR 415. Mr. Burmester, any further record there?
No, Your Honor.
Okay.
On their version, if I came forward and told something on my
Then,
I'd be an
if you would
informant.
please turn to page 3.
I think he didn't do a good job with the
This is a
definition.
revised other acts instruction. 2 questions. First, in the bulleted list, do we want to add any mention of the defendant may have been involved in civil litigation that she referred to as charges? Or do you want to just leave it alone? Ms. Nestor.
No, I think you cured that when it happened, and I think bringing it up now would just bring unnecessary attention to it.
Okay. Any objection to that, Mr. Burmester?
No.
All right. And then, Mr. Burmester, if you'd look at the 1 to 3rd paragraph, I've added some, though not all, of the alternative purposes from Rule 404B. I've added the ones that I think have at least minimal factual foundation in this evidentiary record. Any objections, sir?
No, that was our request.
Okay. Ms. Nestor, any further record there?
No, Your Honor.
Okay. Very good. Okay, turn to page 4. This is the aggravated murder instruction. I collapsed. Oh, I got to change the numbering. I'm sorry. This is why we go through these things together. All right. Bear with me for a moment. The elements are 1, Kouri Richins. 2, intentionally or knowingly caused the death of Eric Richins. I collapsed that for a reason you'll see in a moment when we get to the attempted instruction.
Okay.
3, under one or more of the following circumstances. And then in the second to last paragraph, instead of element 4, it'll say element 3. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
Nothing additional, Your Honor.
Okay. Then if you turn the page, I needed to put the word, the modifier attempted to before intentionally or knowingly caused the death of Eric Richins to make it clear, Ms. Nestor, that you don't have to intentionally or knowingly attempt. You have to attempt to cause.
Yes. I
Okay.
believe that's right.
And so that's why we switched those around.
That's better.
Any objection, Mr. Burmester?
No, Your Honor.
Okay.
There's italics on the last couple paragraphs. Is that for a purpose or?
You know, it was supposed to be beyond, no, that is something I just need to edit to match the original. I know what you're going to say. It's going to say circumstance or circumstance is on page 5.
Also, I just caught by looking at that on page 4, the one before, it should say listed in element 3.
Correct. I made that
Did you catch that?
I did.
Okay, perfect.
Thank you.
Yep.
All right. If you would turn to page 6.
Okay.
Elements of insurance fraud, count 3. Ms. Nestor, I understand defendant's argument. Based upon the plain language of the statute under which count 3 is charged, I think elements 1, 2, 3, and 4 are correct as a matter of law as applied to the evidentiary record in this case. Defendant's request for additional elements language is respectfully denied. Any further record there?
No.
But I think it is important to instruct the jury explicitly about what act the state alleges or believes Kouri Richins performed or committed to commit this crime. This is a starting point, a proposal. I'm not the state's lawyer. I just put something in there to get the conversation started.
So I'll let them talk first because I'm interested to hear what they say.
Other than Richins
Yeah, got it.
spelling, I think that's what we're going to argue is what happened.
Okay.
So, and this may be more just for Ms. Lewis's benefit, who's listening in, because she'll be doing the closing, but I am unclear why submitting the application or making the claim or receiving the money is fraudulent.
Because in the state's theory, and what I understand they are intending to prove beyond a reasonable doubt, is that the application was fraudulent and therefore was void ab initio
Because of the forged name?
because of the forged signature from Eric Richins.
So in other words, the crime is getting someone some life insurance they didn't want, because they both applied. You know, she applied for herself and him.
Well, I think what the state's going to show is that she submitted an application that she forged the decedent's signature, listed herself as the beneficiary after he died, as submitted for the claim, took the claim. Now, count 5 is the signing, right?
Right.
Count 3 is the devising of the scheme to get the money by signing, submitting, making the claim.
So my
Do
concern.
I have that right, Mr. Permister?
Yes, Your Honor.
My-
It's just
Go ahead.
like frequently, when you have a forgery, there's a corresponding count, like a
Right.
theft or
Right.
theft by deception, whatever.
So the only issue I have, I have some issues with that, but the testimony of the True Stage lady, I'm so sorry, I cannot remember her name. I don't mean to be disrespectful. I just cannot remember her name at the moment. Maybe Coates. It might have been Ms. Coates. I'm not positive.
Sand coats.
Okay, good. Ms. Coates. Was that they did not ever investigate or follow up. When they would get an application, they didn't call the person and say, is this your signature? Is this okay with you? That was not something that mattered to them. So we know that Kouri had a right to apply for the policy for herself, clearly, which she did on that policy. She applied for both of them. It was in both their name, like each other is the beneficiary. So they each were getting a policy.
Right.
So,
I'm saying right. When I say right, I'm saying I understand what you're saying.
Yeah,
I'm
right.
not making a finding.
correct. So I don't understand how if if the claim on the death is based on a death that actually happened, and it's a policy they agreed to approve. Once they approved the policy, they approved it. So whether or not...
but I think the state's theory is there was a threshold intentional misrepresentation in the beginning. That is that Eric Richins signed this with the intent that Kouri Richins would be a beneficiary on this policy. And the state's theory is that simply just never happened.
You can purchase insurance and put yourself as a beneficiary on behalf of someone. Like, I could right now get life insurance on my husband where I'm the beneficiary.
Yeah, but you
And
can't
that-
forge his signature.
Can't sign his name.
Well,
Yeah.
if she had authority to if she had authority to sign his signature.
But that's
it's-
a big if. That's in factual dispute in this case. We're just talking about legal elements here.
Gonna lose this one. Yes, you are.
Sounds like this will figure prominently in defendant's closing argument.
Yeah, I guess so. Okay.
Mr. Burmester, besides the spelling error, any...
Wait, before we go on,
Oh,
can I
I'm
just get
sorry.
a clarification? So I can argue, I'm just concerned that if this language is in this instruction, that I'm not going to be able to get up there and argue, this may be their theory, but we don't think any of this is a crime.
You can say exactly that.
Okay, just making sure.
You can say the state had this theory and didn't prove any of it.
Okay. And it does start with the state's theory.
Right.
I just feel like you're telling them in an instruction that that's a crime. That's what's bothering me, right? It's like it sounds like the judge is telling them this is a crime.
No, well, I think this is, in my mind, and you tell me if there's a more artful way to do it in
Right.
your view. There are times in sexual assault cases, for example, where multiple touchings happen of different body parts, and you've got to be real specific in the counts. The state's theory regarding count 2 is touching of this body part on this day. State's theory regarding count 3 is touching of this body part on that day to prevent any ambiguity regarding unanimity. Here, we're doing it for a different purpose, but we're providing specificity regarding the state's theory so that it's clear the state is asserting that she did something other than think.
Well, can we put what our theory is? I mean, I just don't.
But you don't have any burden.
Thank you.
No, but we are entitled to theory of defense instructions. I mean, if you're going to put their theory in, I just think adding that part in the bottom is problematic for a lot of reasons. I think, just like with all the other instructions, they can stand up and say what they think meets these 4 elements any way they want. But if it comes from you, it's like you're saying this is sufficient.
I can take it out if you want.
That's what I would like.
Okay.
Okay, perfect.
Mr. Burmester, any objection?
No?
Okay. I imagine they're going to hear the same thing or something similar in closing, so we'll end up in the same place.
Except now we're back in the position where they could convict her for just a thought.
Well, we were probably in that position by virtue of the Utah legislature when we walked in here today, so I don't know that we're going to fix that in this case.
I mean, there's evidence that whether they believe it or not is another question, but there's evidence that Kouri Richins filled out an application for insurance, submitted it to the insurance company, and they eventually paid it out.
I don't disagree.
So
whether it rises to the level of a showing beyond a reasonable doubt of the elements of this crime, the jury will determine.
absolutely. And I think the only thing that did to help, I mean, because we're not arguing that a bad thought came into her head.
I
That won't be
understand.
argued. But it does help us distinguish unanimity between 3 and 4.
What?
That's the
Well,
one.
I think also the dates.
The
do that
dates are
for you.
different,
Yeah.
absolutely.
But what if we did this?
Yeah.
Just to create an actus reus, because I don't think one exists in this instruction. What if it says intentionally, knowingly, or recklessly devised and enacted a scheme or artifice?
You got to talk to Mr. Burmester about that. I can't unilaterally add an element that doesn't exist in the statute.
Oh, I see what you're saying.
Yep.
Now, you can stipulate to that if you want to create some appellate insurance, but I also take Mr. Burmester's point seriously, and I'm not a appellate or constitutional litigator, but given the evidentiary foundation and the arguments that would be made at closing, I'm not sure we actually have a constitutional problem here.
Right, I don't either.
Okay, well, I guess I would just have a general objection that there's no actus reus in this instruction, but I think the bottom paragraph adds more problems than it creates, and I would ask that that be stricken, but I understand, I guess what he's saying is, don't worry, I'm going to argue it correctly, even though it's not written correctly on this instruction.
Or I
Yeah.
think what he's saying is, even if the statute is somehow defective for not having an actus reus defined,
Right.
the evidentiary foundation in the state's closing argument will
We'll
make
meet
it
it.
clear
We'll cure
that
it.
they are alleging that there were multiple acts committed here.
Okay.
Is that fairly stated, Mr.
Yes.
Burns?
We are definitely not making the argument that somehow the instruction is improper
Right.
or
Yeah.
unlawful.
Okay. Okay. And then, anything else on count 3, Ms. Nestor?
No, sir.
Mr. Burmester?
No.
All right. And then count 5 is just the skinny down version of element 4.
Did we skip? Because on count 4,
I
we
didn't
were,
make any changes.
you left it the same. Got it.
There were no objections to count 4.
Wait, I thought count 4 was the one.
Did I miss some? I apologize.
Yeah.
Let me take a look.
Let me check.
I don't have any handwriting on count 4.
Just a moment.
Athena 0616 says the
Okay,
defense
let's
is
see.
walking all over the judge and prosecutor. I disagree.
There's one. Just a sec.
I think the changes are probably
Mine is clean as
Reasonable.
well.
1 and 2. Just a moment, Your Honor. I'm so sorry.
and the argument they were having there is you can't
Count
have
4
a-
was the one about the fees. Wasn't that count 4? Or was that count 3?
Count 3 was the language from
That-
the statute
that had the
regarding
fees.
fees for services.
You're right, then no, there was nothing on 4. I apologize, Your Honor.
Okay. Take a look at count 5 for me. Let me know if you have any concerns.
Not from the defense.
you can't have a crime with just intent. You've got to have an act
No
also.
objection.
Crimes
Okay,
require
great.
a mens rea, the thought, and an actus reus, the act.
All right.
But the statute
I
doesn't
think
say.
that only, oh no,
have an act
before
in
we
it.
get to spoliation, Ms. Nestor, my apologies. Any, did I hand out the special verdict forms? Did I bring them with me?
So
Did you,
that's
the
what-
amended ones, I don't think we have amended ones.
My apologies. I'll be right back.
No worries.
She shouldn't say no worries. He's the judge. Anyway, that's what that argument was about. The statute, I don't have the statute in front of me, but it evidently doesn't specifically say an act. So they had tried in the instruction to put something in to say it was an act, and she didn't like that because she thought then it was the judge telling the jury that there was an act there. And so that's what that argument was. So they took the language back out. And now the instruction again sounds as though all you have to do is have the mental state. You don't have to do anything. The prosecutor said that's not what they're going to argue. They're going to argue there were acts that match the mental state to make it a crime. That was what that argument was all about. And you heard the judge say they can't fix the statute. The legislature did it. There is a rule of construction that says that you look at a statute, and if there is something missing from it, you can construe it to include that element if at common law the element was there. So that's essentially what they did. They didn't say it that way, but that's essentially what they did. Okay, Scrambled Egg said she watched the Tyler Robinson hearing today, and the judge is not going to let Nestor get away with disorganization and rudeness. Well, I hope you're right, because, I just hope you're right. Well, I don't, there are a lot of people saying she's pushing and she just wants her way and the judge is doing it. I don't see it that way. She's got the obligation to represent her client. And if she thinks the instruction doesn't fairly do it, or if she thinks there's another way to say it, she's got the obligation to do it. And on a couple of the arguments she made, I think she was right. And she's also conceded, in some places, even when she doesn't like the result. I think she's doing a pretty good job. And although the tone is still there, I think it's very different from the way she operated during the trial. Why did the prosecution want no motive instructions? It wasn't that they didn't want a motive instruction. It was the way the motive instruction in the aggravating circumstance sounded as though it might be an element of the crime, and it wasn't. So it was more technical, and they didn't know how to fix it with the language. So the easiest thing to do was to take it out completely and let the prosecutor argue it, and the defense can argue it.
Counsel, we're back on the record. I've just handed you a revised version of the verdict form. Yeah. If you would just read through it and make sure I didn't miss anything.
Okay, I do agree with the comments in here that she's very casual in the courtroom. That was scrambled egg. I do think that's true. I don't think her courtroom demeanor and her interaction with the judge is right. There, I agree with you completely. All of you have said that.
No objections.
I mean, if we don't do trial, now I don't want to be preachy, but I'm going to sound this way, I know. If we don't do
No
trials,
Very good.
will we
Okay.
have lawyers zealously represent
Ms.
the
Nestor,
defendant?
I have a list of practical things I need to talk about, but did you want to talk any more about spoliation sitting here today?
Yes.
Go ahead.
Thank you. Your Honor, may I remain seated?
Yes.
Thank you. So the court has heard in the trial that the night or the early morning that Eric Richins was discovered deceased in the bed, there was a long expired pill bottle directly next to him on the nightstand. The picture of the pill bottle has been introduced as evidence. I believe it's 1-8. I'm not 1,000% positive of that, but I think that's what the exhibit number is. If you look at the picture, you can see there is detritus, or whatever the word is, residue. I'll use an easier word.
Dust.
Residue, dust at the bottom of the pill bottle. There was video or pictures that came into evidence of one of the first responders, Mr. Cernich, taking the pill bottle off the nightstand, and then there was subsequently a photograph that was taken, I think it was by Officer Pimentel, but I'm not 1,000% sure about that either, but one of the officers with gloves on holding the pill bottle took a photograph of it. That pill bottle, there was testimony, was sent with the body to the...
In the body bag, right?
I believe so.
To the office of the medical examiner?
I believe that is correct. And that it was delivered to the medical examiner's office. The final witness of the trial, Officer Driscoll, was asked if they were able to, or still had the pill bottle, and his answer was that they no longer had the pill bottle.
I don't think that
Detective O'Driscoll say that?
No, it was objected to because it was hearsay. Is my
I don't know
recollection.
whether he knows whether they still have the bottle.
No, he doesn't know.
Right.
But he said that he doesn't have. They don't, like the Summit County sheriffs don't have it.
Correct.
Right.
Yeah.
So I don't know if he knows what happened to it at the medical examiner's office or not.
Is there any affirmative evidence in the case about whether the medical examiner's office still has the bottle?
No,
Not that bottle, no.
Okay.
no.
Meaning no affirmative evidence, or they don't have that bottle?
They
No
don't have-
affirmative evidence of this bottle being present or not present.
That's my recollection. I have not rewatched every day of that testimony from the medical examiner.
Well, I do know that the young woman, and I apologize, I cannot remember her name either. I'm just blanking right now.
Dr. Ulmer?
No, the
Ms.
lady
Gibson?
who checked in the body that had
Oh.
the tag, the red
Yeah.
tag on it.
Right.
She testified that what happens is when they open the body bag, that there are their personal effects and the prescriptions that were on scene for purposes of their giving them ideas what to test for, I guess, when they do the toxicology. I assume that's why that's done. I don't know for sure. So I know that she did. My recollection is that she testified it arrived at their office with his personal items. I don't know that we've ever had any testimony to why it was lost or destroyed or what happened to it. It's clearly it's gone because it would have been here if it wasn't. So.
Oh, but yeah, I mean, let's come back to spoliation, right?
Okay.
You have to first show a violation, or that a duty to preserve
Right.
existed.
Exactly.
Then you have to show a violation.
Right.
Then you have to show prejudice.
Right.
So whether or not the duty to preserve existed, they preserved it because it went in the body bag with the body. So
Well-
who is it that you would say violated any duty here?
Well, it wasn't preserved for purposes of the defense to be able to examine it or to use it at trial because it was gone by the time we did our physical evidence examination. It wasn't there anymore.
I don't know that any evidence of that is in the record.
Right. It
Well,
is.
we can do we can do affidavits as to that.
Now,
The
Trial's
evidentiary
over.
record for trial is closed.
No,
That's
for your evaluation purpose, it's not, I don't think your finding is based on what happened in trial.
No, but
Because
I mean,
all the time on
the
Tuesday-
evidence is closed. Closings are happening Monday. To the extent you were a party wanted to make an additional evidentiary showing and have the court make findings sufficient to support a ruling that there was a breach of the duty to preserve, findings regarding the level of culpability, whether it was inadvertent or intentional,
Right.
and what the prejudice is. That time was months and months ago.
No, I disagree with that. So, we could, even now, file a motion to dismiss under Tiedemann based on what came out at trial, plus additional evidence for the court to consider. We're not doing that.
This is not bad.
No, we're not doing that. But I'm saying that if we're asking for a remedy, that there was a duty to preserve under Rule 16 of this hydrocodone bottle. The hydrocodone bottle, by the time the defense team did our analysis of the physical evidence, it was missing. It was gone. So we've never had the opportunity to test it, submit it to a expert, or have it or use it at all, right? So it's missing. There's no question there's a duty to preserve it. They thought it was important enough to take a picture of it. It was next to the body. There's clearly a duty to preserve. We do not have, and I will concede it up front, we certainly don't have any evidence that suggests they intentionally destroyed it. We've just not come across that in any way. But there's definitely going to be some gross negligence here if the main container of potentially illicit drugs, of someone who was found dead of illicit drugs, is lost and made not able for us to recover under Rule 16.
You're putting a lot of freight on Maine. There were other bottles recovered in the house, but
Not,
keep going.
not right next to the body, there weren't. And, there was an unknown dust on the nightstand right where the pill bottle was. Could have been part of that. If it was crushed or if it was snorted or whatever it was, I don't know. So the court has a lot of remedy in how to handle that, right? Like, one option is a Tiedemann motion to dismiss. We did not do that. The other option is to say, hey, we would like an instruction to the jury that there was a duty to preserve this evidence. It was not preserved, and because of that, you should assume that it would have been helpful to the defendant. That's the adverse inference instruction under Cronish versus U.S. So, we're simply asking the court to give us a remedy for the fact that something that was required to be given to us under Rule 16 never was.
Well, but hold on.
Yeah.
You don't have any evidence that the medical examiner's office kept it long enough for the investigators to get custody of it. It may have been destroyed pursuant to normal destruction protocols of the ME's office, along with the body.
Yeah.
They don't keep everything forever. I need more here.
Right.
I understand that this is a good faith argument, but spoliation requires findings, and it is a multi-factor analysis, and I can't skip steps.
Right.
In order to make a ruling as to whether an adverse inference instruction is even appropriate, I got to get through duty and breach and prejudice.
Right.
And we don't have that evidentiary showing.
Well, we definitely have duty. We definitely have that it's material. I think the only thing that's in question is the breach, right? Like, to what level of culpability was the breach? Or
was it breached at all?
Right.
There are things such as rule-based preservation schedules that absent, for example, your client certainly knew that the body was taken, right? She had an opportunity to ask, what else do you have? Are there any personal effects? What are you going to do with the personal effects? Now, I'm not casting any aspersions. I'm just saying there are other facts that I'd have to consider.
Right. No, I agree. I don't disagree with anything you're saying. It puts us in a position where
Should have asked, should have done something.
we might have to have,
And to be clear, you are not limited from making the arguments you just made to me to the jury.
Oh, we will.
Where's the bottle?
Right. No, we'll definitely do that. But what I want is the inference that you got to assume it helped us.
That is, I sit here today,
Yeah.
I don't have a sufficient showing to make the findings that would be necessary to give that kind of instruction under my understanding of the law regarding spoliation.
Okay. If we're able to obtain that for you prior to Monday, can we submit that in writing?
I'm certainly not going to be closed-minded.
Okay. Thank you, Your Honor. Understood.
I'm not making any predictions one way or the other.
Okay.
Mr. Burmester, anything else on the record today?
Yes, I just wanted to add a requirement that there be a showing of reasonable probability the lost evidence would have been exculpatory.
Right.
I don't know why fentanyl would have to be stored in another opioid package. I mean, the testimony was that it came in envelopes, for example. So I would just add that to the argument.
I understand. That is among the reasons I am proceeding with appropriate caution here, given the findings that the court would need to make in any spoliation situation, alleged spoliation situation.
Right.
Ms. Nestel, you've, by proximity, asserted yourself a little bit. Maybe, do you want to talk to Fred for a minute? And I don't know that you have standing to weigh in, but.
After you've resolved all of this, I just
had
a request.
No problem. I'm happy to hear you out in just a second.
Thank you.
Okay. Anything further on that issue, Ms. Nestor?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. All right. Counsel, on my list, any objection to exchanging slide decks related to your closing arguments by sometime on Sunday afternoon or evening?
We actually talked to Mr. Bloodworth about this already, and both sides decided we didn't want to exchange them.
Okay.
So
Fine.
we're good.
Is that your understanding, Mr. Burmester?
I have no understanding of that.
Okay. I'm going to take you at your word on that,
Yeah.
Ms. Nestor. All right.
I'll confirm it again and make sure he hasn't changed his mind. But if he does, what is the time you want us to?
Whatever you all agree to.
Okay.
I just
We'll We'll do it.
I'm inclined to order it if you folks want it, but if you've agreed to
Yeah,
proceed in a different fashion, that's fine.
We kind of had a conversation about it when we called on 4 o'clock yesterday. And, I mean, opening is different because opening, nothing's come into evidence yet. And both sides are very concerned about what's showed to a jury before anything's come in. And we were all very concerned about swapping. We fleshed that out about closing, and we all just are taking the position, we know what's in now, you can put what's in, and if you want to use some creative little thing that is just for, demonstrative purposes, the other side's not going to be able to object to that anyway, so
Understood.
we're fine.
Okay. With respect to exhibits, defense exhibits, Brittany has a handle on. She thinks she has all of them.
Great.
The state's exhibits, she's going to need to interact with the state's team to make sure she gets a bunch. And because the number of state's exhibit is so much larger and they're of varying kinds, there may be some back and forth about that while you're all doing I'm reading instructions and closing arguments. And so if Mr. Burmester, if you can just make sure the state's, whoever's in charge of that for the state is present.
Ms. Steele was here trying to talk to...
So Brittany's not here this afternoon, but if you can keep your eyes on your email and be present on Monday morning, she'll need your help. If you want me to leave it on her desk for her, I'm happy to do it. Okay.
Also, we've been trying really hard to keep track of what we believe has been admitted, just to have a backup. So if we could just, before the exhibits go back,
Yes.
give us a few minutes to make sure we're all in agreement that that's what should go back. And we have a list, we're ready to go. It shouldn't take long, but I would ask the chance to review it before it goes back.
It's my expectation that will take longer than a few minutes
Yeah.
and will involve somebody from both sides of the V and Brittany after closing is complete.
Perfect, thank you.
Some of the exhibits are audiovisual files.
They are.
They need to be on a single thumb drive if possible, or as few thumb drives as possible. The court has an air-gapped laptop that the jury can use to view them. We'll just want to make sure that it works.
And we're fine, Ms. Steele, if you want to provide to us on box what the video ones are, so you don't have to do a thumb drive, that's fine. Just let us know where you put it on box, okay?
I think they need the thumb drive for...
The jury does.
The
not
jury,
defense
but
counsel.
I don't want you to waste money on us. You can just put it on box.
And then, notwithstanding our conversation regarding the 900 pages of Carmen Lauber's interviews, turns out there are a lot more transcripts that were admitted than I recalled. Several that are companions to the audiovisual files. As I understand it, there's no objection to those going back to the jury, correct? Because they're not in court testimony. They were admitted as exhibits. They're going back, correct, Mr. Burmester?
Yes.
I believe so, but I will check with that. I mean, we were, there weren't too many transcripts. Most of them were redacted transcripts that we had all agreed on, like the.
Understood. They're all portions.
Right.
For
Okay.
example,
Good. I was like, just
there
getting
were some
panicky.
several recorded phone calls.
Right.
All of them have
Right.
a companion transcript.
We did agree to those.
Okay.
The parties did, but now I'm panicking if there was accidentally some big transcript that slid back past us that we didn't see.
I don't think so. Brittany
Okay.
just wanted to confirm,
Okay.
based upon the conversation we had in the record, where I expressed some concern about a particularly lengthy or complete transcript getting undue influence.
Right.
She just wanted to make sure that she
Right.
understood the state of affairs.
No. I
If
think-
it's been admitted as an exhibit,
It goes
to
back.
the jury.
Right.
Yeah.
I agree.
Okay. All right. Anything else today, Mr. Burmester?
Thank you, Ron.
Ms. Nestor?
Corin
I
girl,
assume,
Ron. Thank you
since we're
so
doing
much.
so good and we're so far ahead of schedule, that you're not putting a timer on our closings?
No. Not putting a timer on
Please
the
put
jury
a
either.
timer on.
Okay.
All right. I'm going to have to do some breathing exercises before I dismiss the alternates, but it'll be all right.
I know. It's pretty amazing. We haven't lost a juror in
They are
a
a
3-week
hardy
trial.
group. And I'll make clear to them that they're not released.
Yeah.
They're just, they need to abide by all the rules in case somebody falls ill, suffers a tragedy during deliberations.
Right.
All right. I appreciate your time and effort this morning, Ms. Afternoon, Ms. Nestel. Sure, happy to listen.
Well, who is this?
As you know, I represent the victims in this case who are here today. They've been here every day filling the row. We have a special request for Monday. I don't know if it'll deviate from the court's decorum order, but if it does, we think it warrants a special decision or order from the court. And that is we're asking for the victim's family to be able to take that second and even third row during the closing arguments. Of course, nobody can or anticipate when the case was going to close or when closing arguments would be, but that's a really important day. It's an important day for the victims to exercise their right to be present, which to be meaningful means they want to hear and see as much as they can. So I think they've been very abiding to the court's decorum order. This is really important for them. There were a lot of witnesses who were subpoenaed and weren't able to come in, maybe didn't even end up testifying, but they want to come as well. So during the pretrial proceedings, the victim's family had 2 rows that they filled regularly, and there are a lot of people who loved Eric and supported him and who would like to be here that day. And to prevent people from having to camp out all night at the court's doorstep just to make sure that they get in. Our request would be that they get the second and third row designated.
Chris, have we handed out wristbands for Monday yet?
No, sir. Our plan is to hand them out for the decorum order before 0800.
So I'm just going to sound this
interesting
out in real time.
They didn't designate
What I
already.
can't do is change the rules regarding odd and even midstream based upon genuine empathy for one side or the other. But I can steal some rows back from people that do not have a familiar connection to the case. And so, Chris, it sounds like I could say rows 2 and 3 are going to be for whoever would have gotten row 2 in on whatever odd or even day Monday is, and rows 4 and 5 can be for whomever was going to get it on that day. So I can double the amount of space. I just can't switch the order.
Okay, and I think possibly the defendant's family would have been on Monday. Of course, again, we didn't know the trial was going to end, or that important day would be
Certainly neither
on
did
Monday.
I. Yeah.
If those rows are not filled, can those seats be filled?
No, it makes it very hard for court staff to manage who's sitting where and to make sure that everybody is behaving. So I got to have clear rules, but I can double the space. I mean, let's be clear. What I'd be doing is excluding the rest of the public.
Right.
But let's put it blank. Instead of 1 row for Miss Kouri Richins' family, 2 rows for the public, 1 row for Eric Richins' family, it would be 1 row for the media, 2 rows for Kouri Richins' family, 2 and guests, and 2 rows for Eric Richins' family and guests.
Okay, thank you.
Chris, now that I've said that out loud, that's an idea. I got to make sure I did not create any trouble.
I have to deal with the public.
Well, we can send something out, right?
Yeah.
I imagine that I could ask our media partners to help me spread the word. So we'll get to that. Okay.
So I'm happy to talk to Ms. Richins' family and see if they need that second row. And if they don't, I can communicate with Mr. Palmer and tell him there will be 1 row for the public.
I'm probably just going to make this decision now so there's no ambiguity so we can get ahead of it.
Okay.
So that people aren't coming to the courthouse 2 days from now with an
Okay.
expectation.
Okay.
Will you give me 5 minutes to talk to Chris to make sure I'm
Yes.
not working at cross purposes with the security plan?
Yes.
All right, let me take a 5-minute break, folks. Thank you.
Well, that was interesting. I mean, in other courtrooms, they designate, 1 row for family, 1 row for victim. It appears here what they did was the first row was media, and then rows 2 and 3, 1 was Kouri's family, 1 was Eric's family, and depending on the day, they flipped who got row 2 and who got row 3. If anybody heard that differently, let me know. And what the judge is now proposing is that each side get 2 rows apiece, and rows 2 and 3 will go to whoever's day was to get row 2 on Monday. But I'm really that's very interesting. And if he does that, then there will be no seats for the public on Monday to hear closing arguments. So, but that's what that sounded like. And then I had a question about what the spoliation meant. It's with regard to the loss or destruction or whatever of that pill bottle that was on the nightstand on Eric's side of the bed on the morning of the 4th when his body was removed. There is a rule that if evidence is destroyed, the defense doesn't get to see it, and you heard the judge. Under the rule in Utah, you've got to show there was a duty to preserve it, that there was a breach of that duty, and that there was prejudice to the defendant because of the breach of the duty. The breach requires an intent to destroy or to misplace. It's not simply accidental. So those are the elements. If those elements are met, then the whatever side, it would, in this case, it's the state, if it's the defense, gets a jury instruction that tells the jury that because the pill bottle, in this case, the pill bottle was not produced, that the jury is entitled to infer that had the pill bottle been preserved and provided to the defendant, it would have provided some exculpatory evidence for the defendant. So if you understand that, it's really, if I have, the theory is, if I have evidence and it's destroyed or lost, and you can prove I did it with intent, then I'm entitled to you're entitled to an instruction that says, why would she have intentionally destroyed it unless it would have helped us? So that's the effect of the jury instruction, but you've got to find a duty in the first place. And you heard the judge say he wasn't sure there was a duty. Maybe the coroner's office has rules about when they get rid of things. The pill bottle apparently was in the body bag. You have to show a breach of the duty, even if there is a duty, and it has to be intentional that you misplaced or destroyed. And then you have to show that because of its absence, that there's prejudice to the defendant. You heard the state say
closings on Monday and the period of jury deliberations. First row, as usual, will be for members of the media with authorization to have a seat in those rows. Whichever family, whether it's Eric Richins' family and guests or Kouri Richins' family and guests, is entitled under the current odd-even switching scheme to the second row will get the second and third. Whichever family and set of guests is entitled to the fifth will get the fifth and fourth. Keep in mind, they're going to switch each day. So if the jury keeps deliberating into Tuesday, it'll be 2 and 3 versus 4 and 5 switches. Mr. Palmer, court security director, will give counsel, defendant's counsel for defendant's family and guests, state's counsel for, unless you want to be the point person, Ms. Nestel, it's up to you.
I can do that just to take the burden off of them.
All right.
Yeah.
Ms. Nestel, on behalf of Eric Richins' family and guests, is going to give you 24 wristbands. And it's up to you who gets them. That'll be per day.
Thank you.
Okay? Means you got to be here, somebody from your team and somebody, Ms. Nestel, you got to be here no later than 8 a.m. each day.
Yeah.
All right?
I'll do it.
Very good. We're all going to buy Chris Palmer chocolates and flowers because he's going to take some flack about this. I will issue an amended decorum order to make it clear this is the way we're doing things. It's the fair way to do it. To the extent you can include this in your reporting about what's coming on Monday, I'd appreciate it, just so people aren't showing up unnecessarily. Okay. All right. Anything else, Ms. Nestel?
No.
Ms. Nestor?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Folks, I appreciate your patience. Please travel safe. Ms. Richins, I'll see you Monday morning. Take care. Court's in recess. Thank you. Grace, I think you want to...
Did anybody hear an answer to the question whether there would be time limits on closings? That's the real question I wanted answered, and I didn't hear it. Anybody in the chat hear it? So anyway, I hope you understand spoliation now. And the issue that you heard the defense keep saying was that they could show that there was a breach of the duty, although maybe not, or no, they're not claiming intentional, but they're claiming gross negligence. And the judge you heard say, well, you had the opportunity to put in evidence. What do you want me to do now? And so he said tentatively no instruction, but she said, can we have the weekend to look at more law and make another argument? And he said, yes. So we're probably going to start with that on Monday. Closings probably won't start when we thought they were going to start, because there is going to be some argument that she's going to make that she's entitled to this instruction, even though they didn't get some of the evidence in that they needed to get in to be able to make this claim. So there we are with that. Are there any other questions in the chat or no? Let's see. I don't see anything else. So I think you all, oh, here's a question from Affiliate. Do I think the jurors will be deliberating from Monday? I don't know how long these closing arguments are going to be. If there's a limit on the closing arguments, yes, I think they will get the case on Monday, because what has to happen on Monday, I'm assuming that Nestor is going to be providing material to the judge about getting this instruction. They may have some last minute review of the instructions that were approved today. Then, depending on how long the closings are, if the closings are limited to an hour on each side, I would think that they would be able to get to the closings certainly after lunch on Monday. And then you've got the instructions to the jury. So it might be a little close, but I think the case could be submitted on Monday, otherwise first thing Tuesday. That's my best guess on this. Okay. No, I can't spell foliation for you because I never heard it used in this context. But I think what they said was SF, spoliation, which means, in the context of grass, it means it gets destroyed. I had never heard it used in legal context, but the concept is not a surprise. It's just the way they name it that is a surprise. Oh, so .u forum heard that there would be no limit on closings. Oh my, I'm very sorry about that. Because if there are no limits on closing, this case is not going to the jury on Monday. That's my guess, and I think it's a guess based on past practice, past experience. Okay, judge said no time limits. That was Mary Hirsch, 863. I don't understand that. I don't see why they're allowed to go on and on and on and on, but that's what we heard, no time limits. Okay, I don't see any more questions in here, so let's call it what time is it for you? I don't see 11, so it would be what? 6:43 in New York, 4:43 in Utah, 3:33 in California, 5:43 in Chicago. I think I've done all time zones. I hope I did them correctly. Let's see. I don't understand this question. There's a question from Ephraim Notes. Why does it matter what it was? What does that change? I don't know what the it is there. Okay. Let me see if I find anything else. Okay, Simone Janot wants to emphasize that Kouri texted Josh that all her previous prescriptions were still in the medicine cabinet. Well, the state can use that in closing. Okay. Let me see if there's anything else. I'm continuing to look. Those of you who haven't subscribed yet, I'm getting close. I really wish you would subscribe so I can get to 15,000 tonight. It's nearly midnight here. I would love to at midnight be able to say I'm at 15,000 and now I can start the way to 16,000 subscribers. Okay. Who do I think will give a better closing argument? I think, they've got different purposes and that means that there will be different things each side does in closing argument. The state wants to provide a clear case that rolls in all the evidence that shows how you can get to beyond a reasonable doubt on each of the counts. They want to roll in all the inferences, explain it all, and they want to do it in a way that is very clear, very crisp as to each element. The defense wants to pick holes in the prosecution case. They want to confuse things. That's going to be their effort on Monday. And so they've got different roles. If we're going to say we're going to evaluate it on how clear, succinct, and understandable, rolling in all evidence, then the state would have the better closing on Monday. But they've got different purposes. All right, let's see where we are. Let me go back here. And for all of you who became members today or provided gifts today, again, thank you so very much. Okay, let's see. Lester has managed to get away with being rude and uncouth all through the trial, manipulative and just plain wrong when recounting what the person on the witness stand said. Okay. What is a what? Thresh. I think there's a typo, scrambled egg, in what you said, so I can't answer it. Okay. Those were the last questions that are in here. I guess I'll see you on Monday at... Did he give a time? I didn't hear him give a time either. It's going to be an 8:30 start on Monday. I didn't hear him say anything. But did someone in the chat hear? So he ruled on everything, and she may be bringing in another argument about being able to get that instruction. My prediction is the answer will be no to that instruction, but we'll see on Monday. 8:30. Thank you, Monique, for listening, Monique Dawn. So 8:30 on Monday. Oh, somebody else said no time limit. So now I've got 3. Monique Dawn said 8:30. Sammy K6F heard 8 a.m. And someone else there heard Angela McCartan heard didn't hear a time limits. Thank you so much, Jenny Moody, for the gift. I really do appreciate it. 8:30. Dot U Forum says 8:30, and Heidi Beathard said 8 a.m. for brackets. I don't know what brackets means. Oh, Pete 4988 said 8:30. Melva Monker said 8:30. The majority of the people who heard something said 8:30. I'm going to assume 8:30 has never started at 8 that I know of. So 10:30 Pacific time. 10:30 Mountain time, 9:30 Pacific time. 11:30 Central Time, 12:30 Eastern Time, and 5:30 Italy time. Do I have that right? I think I do. What? No. Something sounds wrong. 8:30 Pacific Time, 9:30 Central Time, 10:30 Eastern Time, 3:30 Italy time. Okay, we'll all see each other on Monday. Have a really nice weekend. So long.